I was 5 years old when the going got tough. I remember it so vividly. Standing in the hallway, holding hands with my sis while my parents were shouting jointly. Years went by, situation got worse since my mom and dad stopped talking at the door. Now my sister and I became like some kind of toy where each parent grabbed onto one of the arms. But I'm now happy, 'cause I shut myself out of the misery. Don't let it come to my head, 'cause it's not my responsibility to fix the broken dream of my family. It's not my fault and it will never be, 'cause I'm now happy, and it makes me so damn proud of me. Proud of me, proud of me, proud of me, proud of me. I was 12 years old when my daddy got told that he couldn't see us anymore. Wanted to stay with my mama, I just wanted one home, but nothing will be like it was before. Oh, but I'm now happy, 'cause I shut myself out of the misery. Don't let it come to my head, 'cause it's not my responsibility to fix the broken dream of my family. It's not my fault and it will never be, 'cause I'm now happy, and that makes me so damn proud of me. Proud of me, proud of me, proud of me, proud of me. But now I'm still trying to fix everything that we had for my sister and I. We still have a long road ahead, but she's all that I care for. No, all that I want is for her to feel happy. Oh, happy that she shuts herself out of this misery. Don't let it come to your head, 'cause it's not your responsibility to fix the broken dream of our family. It's not our fault and it will never be, 'cause I'll hope we'll be happy, and you'll say I am so damn proud of me. Proud of me, proud of me, proud of me, proud of me. Proud of me, proud of me.
Welcome to day 2 of PASG 2021. I'm Bill Burnett, the president of the Parental Alienation Study Group. I'm speaking to you today from Nashville, Tennessee, in the United States, where I am a professor in the Department of Psychiatry at Vanderbilt University. I hope you enjoyed the presentations yesterday during day 1 of this conference. Of course, the theme of this meeting relates to the prevention of parental alienation. I want to say a few words about the history of PASG and how this organization gradually came to recognize the importance of prevention. When my colleagues and I first thought about the creation of this organization, which was in 2009, we talked about the importance of having parental alienation officially recognized in the Diagnostic and Statistical Manual of Mental Disorders and also the International Classification of Diseases. I'm referring, as you know, to DSM-5 and ICD-11. My colleagues and I developed strategies for approaching the DSM-5 task force at the American Psychiatric Association and the ICD revision organization. We published this book, Parental Alienation, DSM-5 and ICD-11, to explain why parental alienation should be an official diagnosis. As time went on, PASG grew in size and our members became interested in other aspects of parental alienation. For example, practitioners devised and published articles about interventions for alienation. More specifically, interventions for mild, moderate, and severe levels of alienation. And researchers have published outcome studies of these interventions. For example, outcome studies regarding two programs, Family Bridges and Family Reflections, were published several years ago. Even now, a new outcome study has been accepted for publication regarding the program Turning Points for Family. In addition, as time went on, we thought it was important to have a standardized and generally accepted method for identifying parental alienation. We developed the 5-factor model for the diagnosis of parental alienation, which was explained in a journal article in Ireland, that is, the Journal of the Family Therapy Association of Ireland. Also, the 5-factor model was the organizing principle of our book, Parental Alienation, Science and Law. It seemed inevitable that members of PASG would become more and more interested in the prevention of this mental condition. Of course, prevention is a step beyond the topics of including alienation in DSM-5 and ICD. It's beyond the criteria for the diagnosis of this condition and interventions. The PASG members who led us in this direction were Nick Child, David Pearl, and Philip Marcus. With their guidance, we have created the Parental Alienation Prevention Committee within PASG, and the co-chairs of that committee are Mary Alvarez and Chris Turner. So our interest in this topic will continue. As Nick Child has said many, many times, interventions for parental alienation are like rescuing drowning children from a river. But prevention programs are like moving upstream and catching the children before they fall into the river in the first place. Of course, our interest in prevention of alienation led us to this conference with the title, Protecting Family Ties After Separation. All of us who are here in Brussels today and who are participating in this conference online greatly appreciate the leadership of Olivier Van Hollen and Marie-France Carlier in creating this conference under unusual and difficult circumstances. I mentioned a few minutes ago that PASG was first envisioned in 2009. That meeting occurred in Florence, Italy, and we refer to that gathering as the Committee of Florence. Here's a photo of friends and colleagues who attended that meeting in 2009. Starting in the back row, we see Christian Doom, Benoit Van Dieren, Wilfred von Bach-Belleau, Anya Hananini, Ursula Kojo, Paul Bensusan, and Olga Odinets. Ursula and Olga gave presentations at this meeting yesterday. In the front row are myself and Lena Hellbaum-Joger. Lena organized our second international conference, which was in Stockholm, Sweden. Lena is attending this conference by Zoom. And finally, Edward Bachelor. Edward died in 2010. Since that day in 2009, this organization has grown to more than 800 members. Our members consist of mental health and legal professionals who are interested in this topic, and also parents and grandparents who are sadly alienated from their children and grandchildren. Today, we have members from 62 countries on 6 continents. We don't advertise and we don't charge membership fees or dues. Prospective members find out about PASG by word of mouth, through our website, and by reading this notice at presentations and conferences. PASG is only 11 years old. This is our 4th international conference. We are starting to plan for our 5th international conference in Australia in September 2022. I know you will enjoy the rest of today's conference in Belgium, and I hope to see you in person next year in Australia. Thank you for your attention.
Bonjour tout le monde. Maintenant,
Good morning, everyone. I'm very pleased to introduce Hans Christian Pristen, so I will speak German.
Hans Christian Pristen. He is a judge of the first hour. Many years ago, he was part of the. He contacted the German Constitutional Court, and he had the motion that when there is a separation, that the custody be given only to one parent. That was the rule, and he attacked that. He stated, we need joint custody, and he was the trailblazer to bring this about, namely that not one parent be marginalized and excluded. He has remained active as a family judge. He also worked as a lawyer, came back to being a family judge. So as judge, as lawyer, he has covered the whole breadth of functions, and that gave him a lot of experience on the reality in the judicial sector. And he wanted to highlight his master teachers were the children. The rights of the children, the needs of the children have always been his focus interest throughout his entire life, and throughout his entire life he has represented the needs and interests of the children. He continues doing that. Now he works with other groups in order to fight on behalf of the children and their rights not to be violated physically speaking. So actually he is opposed to mandatory vaccination. So he is the advocate of the children and of the interests of the child. I think he's the best advocate children could wish. Thank you very much, dear Uschi, for your introductory words.
Erfahrung aus unterschiedlichen Rollen mit Ihnen zu teilen und mit Ihnen zusammen letzten Endes dann also auch Ideen zu entwickeln, Visionen zu entwickeln, wie wir verhindern können, was wir heute jetzt ganz besonders auf dem Plan haben.
And it's also about developing ideas and a vision how we can get cracking with the topic we are discussing. No. Okay. Now, what's the current situation? I think it's similar to what I experienced in 1977 when I was a young family judge. So what you observe in a small scale, you now see big scale. When I remember back, well, suddenly I found myself in family law. I knew nothing about the needs of children, and I had to make decisions as to parental custody without knowing what is the situation between the couple, what can they still deliver and what not. So I understood one thing. We as legal experts don't have a training in order to really have discernment here. And without that understanding, we are rather lost. In Bielefeld, I gathered judges and told them, this must not be. We are expected to deliver something for which we are not qualified. So we cannot do justice to what our task ought to be. So we need here a change in approach. So for 50 years, I've been dealing with these questions and issues. And it was always about the situation of children facing situations of separation. But not only in such separation. Whenever the state mentioned and thought that they have to intervene as a state in the parental rights, I was active. You heard about my motion to the German Federal Constitutional Court, and there is a reason I did that. It was an early experience that raised my concerns, and I made certain that the judges in the town of Bielefeld at least got some extra lessons from 2 psychologists. And they told us right at the beginning, you are legal experts. If you want to talk to children, you cannot talk to them if you do not understand what the terminology is about, the well-being of the child. And I was told, don't get them to court, because when they give answers in court, you cannot rely on these answers. They will deliver what the father expects, or what the mother expects, or what the judge expects. And it's such a burden on the children if they find themselves in court. Go and meet the children at home. And I said, I'm a judge, I cannot go to the houses. If I visit the child, maybe the mother has to be present, but the father is outside. I'm biased. Okay, or with the child alone, yes, might be an idea. And I dared go to the house, go to the homes. I talked with the parents, I talked with the lawyers, I got an invitation, and both parents had to go out. Was not easy. My goodness, I was nervous. I entered uncharted territory. And it was interesting to observe the children, to see them act and react. That was incredible. I started with the assumption I can make an easy decision. I can regulate custody and contact. But I understood now, if that is my decision, it would not be better for the children, because I also have to see what happens between the parents. Are they still at war with each other or not? And I concluded, my job is to protect the child. My job is not to mollycoddle the parents. So we have to see all aspects of the situation, and I decided to bring in experts, advisors, who reserve their time to talk to the parents, to find out if the parents can refine their role as parents together. So that was also the background why I contacted the German Constitutional Court in order to work more towards joint custody. And I can tell you, in all my years of experience as family judge, it was never necessary to embark on coercive measures to convince the parents. Now the question. The situation still remains difficult. Why is that the case? And our legal system seems rather helpless to this day. so that we have colleagues as family judges and they work based on wrong assumptions and have to use wrong instructions. So imagine you have a judge and rather at the outside, rather at the surface, he has to make his decisions. Imagine a parallel. We take our car to the garage because the oil lamp signals a problem, and all the mechanic does is take out the oil indicator. So the legal instructions are still designed in such a way that they just look at symptoms. And that is not a good support for the judge's decision in order to really protect the needs of the children and the rights of the children. Needs of the children and rights of the children. Those are my two buzzwords. And obviously, this is not really reflected in the legal text. So the legal text talk about the well-being of the child, but allow me to give you some background information as to the foundations for all of us, not just in Germany, but internationally speaking, we have a foundation. And it's not very complicated to talk about this foundation, and I want to start with that. So the basic rights, the fundamental rights, I hope I can show you what I'm referring to. The fundamental rights of the children. And on the 1st of April 2008, the German Constitutional Court highlighted that as well. Allow me a quote. The child has its own dignity and its own rights. As a bearer of fundamental rights, it is entitled to the protection by the state and the guarantee of its rights guaranteed by fundamental rights. A constitution which places the dignity of the human being at the center of its value system cannot, when ordering interpersonal relationships, in principle grant anyone rights to the person of another which are not at the same time bound by duty and respectful of the human dignity of the other. This also applies to the relationship between a parent and his child. The parental right is therefore inseparable from the duty of parents. This means the child is entitled that the parents take care of it. So parental right involves always parental duty, duty that has to be respected. And Article 2 as well and Article 1 highlight these various aspects because this ensures the family tie, the family relationships to the child. The parental relationship, their care, are very significant in order to make certain that the child can develop into a personality that is respected for its own right and does the same to others. These are basic fundamental legal texts. They talk about rights of the children, and that is not vis-à-vis the right of the parents, but the duty of the parents is the vis-à-vis. So we have to be careful when we use our terms. Shared custody often may imply a right given to the parents. No, it's a right enjoyed by the child. And there are international texts. And they are to be applied as valid legal texts in Germany and in many other countries. They highlight the very same aspects, and they give us an option how to define what is still lacking. So, we often face that the rather authoritarian judge makes decisions on the life situation of parents and children and lacks the tools to do a sound decision. And now, the UN Convention on the Right of the Children. Article 7, passage 1. The child shall have the right to know and be cared for by his or her parents. Article 8. States parties undertake to respect the right of the child to preserve his or her identity, including family relations as recognized by law, without unlawful interference. And now, an aspect which we haven't really been seeing yet. Where a child is illegally deprived of some or all of the elements of his or her identity, states parties shall provide appropriate assistance and protection with a view to re-establishing speedily his or her identity. Think about this. And Article 16. No child shall be subjected to arbitrary or unlawful interference with his or her privacy, family, home, etc. And we read, the child has the right to the protection of the law against such interference or attacks. And Article 19. State parties shall take all appropriate legislative, administrative, social and educational measures to protect the child from all forms of physical or mental violence, injury or abuse, neglect or negligent treatment, maltreatment or exploitation. And Article 37. The states parties shall ensure that no child shall be subjected to torture or other cruel treatment, etc., etc. These are fundamental legal texts upholding the interest of children and how to understand the needs and rights of children. And this is to be seen not just by the parents, but by all of us. We as a community, we as a state have to do our level best, everything possible to make certain that parents and the families are given the best of support, whatever is necessary in order to tackle their duty. If you look at the legal text, it's like a bit of a non-starter or a bomb that didn't explode in the war. We are often not conscious of this, but we often find these aspects. These are like unexploded bombs, but we step on them and then we have an explosion. Now, why do I express it this? Just look at the German Civil Code. So if parents live separated for a certain time and are entitled to custody, then it can be requested that the family law give the custody to only one parent. And this has to be granted as soon as the other parent occases, or if the child is at least 14 years old, or if you can be is to be expected that this decision serves best the well-being of the child. The well-being or the interest of the child. How can be something there that serves the well-being of the child best if at the same you violate a fundamental right of the very same child? So I see here a contradiction. And I would say this is like an invitation to the court, if the parents are still at war, etc. Let's get cracking and do something here. So the court is invited to intervene in the competence of the family and to make a decision that is a lasting one. And what else happens? So one parent alone enjoys custody, or even visiting the child is limited to some hours or some days because there is a consistent conflict among the parents. What do we observe? We observe the following. The child loses the important ties to the absent parent, still necessary to develop his own personality, and the child also loses 50% of his guarantors, of his potential guardians. You might have the parent with custody who is ill or can no longer do the job, and then family members should be called on first to take care of the child. But the family ties to the marginalized parent is now a problem. And if there's an ongoing conflict, you cannot expect that someone has the idea the grandparents, the aunts, whoever is there as a relationship could be included. And here also the German Federal Court has decided, has underlined the importance of family ties. And there was a grandmother who came with a complaint, and quite rightly so, because she, the grandmother, was not considered as a caregiver to her own grandchild, and it was placed in foster care. And the Constitution all talks about the protection of the citizens whenever there's an infringement, a violation of fundamental rights. Namely, the state has to follow the principle of proportionality. Already in 1968, we have a decision by the Constitutional Court. I have to press here the button. Decision on parental behavior. This does not mean that every failure or negligence entitles the state to exclude parents from care and education, or even to take over this task itself. Rather, the state must always take into account the fundamental primacy of parents. And here the principle of proportionality also applies. Nature and extent of the intervention are determined by the extent of the failure of the parents and by what is in the best interest of the child. So how you best serve the right of the child, I would put it. The state must therefore try, as far as possible, to achieve its aim by helping, supporting measures directed toward the establishment or restoration of responsible behavior on the part of the parents. Now, how can we combine this? So proportionality obviously doesn't seem to be a big deal when you decide on custody questions and visitation rights. And at the same time, we are Article 19 in our German Constitution. We read, in no case may the essence of a fundamental right be affected. The essence of fundamental right must not be affected. Please give that some thought. The child has a fundamental right to enjoy both parents, and here that fundamental right is violated for good. And another aspect, we have Article 1 of our German Constitution, which applies generally. The human dignity is inviolable. Human dignity means wherever it's about the rights of the human being, you have to see the entire human being. Please, not just limit yourself to a formal hearing. That might be sufficient when you're talking to adults, but it will never be sufficient when you're talking to children. So there must be the option to bring in the whole personality to influence the proceeding, to come across to the various actors and players, like the judges, like the social workers, etc. Now, I mentioned to you that I went to the homes of the children, and that was an eye-opener. When being at home with the children, they give different signals, generally speaking, different signals with regard to their preferences. A 3-year-old girl getting onto the lap of her mom and take the necklace of the mother to give it to the father, or a young girl who was very silent, and when I leave with the father, she just cries, "Daddy, stay." When you observe this, when this becomes visible to all parties involved, including the judge, then something happens, and Professor Klemmer describes this. This is the moment where the parents no longer are innocent warriors, because they have realized what it really means to their child. That's a change of climate, of atmosphere. And it also means that the parents have a significantly enhanced willingness to get advice, to be counseled. So now you can work with that and give it some time and check after a certain moment to understand How are the parents dealing with it? Hearings. So how does it happen? It's just a hearing. It's a verbal questioning in a strange environment. So it does not look at the concrete personality and abilities of the child. It means the child does not have the opportunity to really show and express himself or herself, verbally and non-verbally. And it is not seeing really the potential negative impact certain decisions are going to have. And it often creates feelings of guilt in the child. This is an added hazard for the health of the child. And what does Article 1 of our German Constitution states? The human dignity is inviolable. What about the child's human dignity here? So it's about the rights of the children, it's about the rights of the families, and it's not about egotistical expectations which you may have at a certain moment. It's important to be aware of this in order to ensure a healthy development for the child, where it also develops a healthy self-esteem and understands that it has importance. Now, the consequences. I try to give you an idea here. I would state as following. Something is absolutely necessary that needs to happen. And it's a challenge. Psychology, pediatrics, humanities, and legal professions, legal sciences, have to be fused, have to be merged. It needs to be part of the approach by the judge. We cannot expect that the judge will know it all, but we need here a properly designed advocacy on behalf of the children. And it needs to start in the parliaments. When was it? 2016. I talked to the Child Commission of the German Parliament. I described the situation of children in Germany when facing court proceedings. And I had a lot of statistical material to back me up, namely to show how dangerous the impact can be, and usually is. And it's not just the children and the families who need a representative, and that might be rather a random choice sometimes. No, what they need above all is the following. The parliamentarians who make the laws have to get acting. They have to be aware that the legislation needs to be aware of the children's rights and interests. So we have parliamentarians who are incompetent. We need to overcome that incompetence. So they need good scientific input. And let's face it, parliamentarians come from all walks of life, but they need to get this input I'm talking about. And a parliamentarian, first of all, has also to view the executive, which has to execute the laws made. And laws are not designed to stroke the ego of the executive. Laws are designed to protect the people, the citizens, because the citizens are holding the power, not the government. So the parliamentarians making the laws need skills, independent of their political affiliation. They need input, they need advice. And they need concrete rights of initiative as well to check incoming legislation and maybe review existing legislation. And I also put this in writing, which probably will be made available to you. I have a whole list of recommendations. So there is definite urgent need for action on the legislative side. If we truly want to achieve a democratic situation where the three branches are truly separated power branches and control each other. So thinking of the judicial side, there are problems there as well. The judge simply is not prepared to understand the psychological and mental needs of children. The judge is not even qualified to see these needs. The judge is very dependent on the expertise, on the opinions coming from third parties. So that may be rather randomly chosen so-called experts in some cases only. That should not be. So it's very, very necessary that we see some action, that we see some change. In order to protect children and families, we need to organize a representation or a representative where you have both elements merged, where you have sound support for the judge and for the court, in as much as such support and help can be done. And there are other conclusions and consequences. For example, the children's advocate the parliament has also needs to be seen. That needs to be the right person. That needs to be a person, or rather a group that is truly independent. They need to be true advocates, and they need to work towards having advocacy options where people are, and to offer that free of charge. Whenever there is a conflict, whenever there is a crisis where you infringe in the rights of children and of families, you need this institution where it happens, ready to act, to give advice to the family, to support the child, and to make certain that they are represented. And something else is necessary. When you think of the legislator, we need to create the following situation, where formal laws are being reviewed. In other words, we often think of a mere functionality of the courts. They just look at the symptoms. We must overcome that. I think there is interesting work ahead. It's very necessary to do this because there is a lot of dust that has settled on a lot of legislation. So we need to shake that up and review it and change that, adapt that, in order to set the focus on the rights and interests of the children truly. So quite a few implications, quite a few conclusions that are ever more necessary than before. Why do I say this? We have corona measures. And the assumed existence of a virus where we see the need to fight, to engage in battle. So it's already the warrior language used. And it's a measure that is dictated from the top down. Though it's not the judge, but it's the state, the government, that dictated to all of us, making all of us little children who have to be obedient to the state. So if you look more closely at it, and I also had to deal with penal law, this is one thing in my understand. It actually violates a penal code. For example, the German penal code, if it's about a person younger than 18 years in Article 225 of the Penal Code, if you endanger their health, create negligence, etc., then you will be punished with prison. Or if the perpetrator engages in an act where the person is close to danger of dying or of suffering bodily or mental harm, of a lasting nature, then we face the following situation. Hüter is a brain researcher, and he explained this. Here, one of his books, and especially his contribution, Pathways Out of Fear. Now, finally, two books, allow me to refer to them. Bruce Lipton, a cell researcher. I think that is something helpful to rediscover ourselves and to leave behind us this position as mere children. And I think that's very interesting and engaging with regard to attitudes towards health and illness. And he gives research on how our experiences also impact our genes. Another book reflecting a Congress in Düsseldorf, Separation or Divorce Hurts. And finally, from Mr. Hüter, a little bit more brain mass, please. So that's what I wish for all of us. Thank you very much for listening to me. Thank you for having invited me, and I look forward to the cooperation which hopefully enables us to put into practice a few of these ideas.
Danke, Hans Christian Pristine. The next speaker is Marc Juston. He's a French judge which has almost more than 30 years experience with parental alienation in France. Unfortunately, he's one of the only judges in France who had these insights, and he's going to do an explanation about that.
Bonjour à tous et à toutes. Je voudrais remercier les organisateurs de m'avoir invité, Monsieur Olivier Van Allen et Marie-France Carlier. Je ne vous cacherai pas que j'aurais bien aimé travailler avec Marie-France Carlier. Malheureusement, nous ne sommes pas dans le même pays et nous n'avons pas le même âge, donc nous n'avons pas pu travailler ensemble, mais on a réfléchi ensemble. Je voudrais aussi remercier tout le travail effectué en France.
I would like to thank everyone for the work on parental alienation under the chair of Olga Ordinez, which is a huge investment that enables to think together in an efficient way on parental alienation. So I'll try to be short in 20 minutes. It's true that full conferences could be devoted on the children's narrative. So in 20 minutes I can't be very precise. So I've been a family judge and a children judge for many years, but I also chaired the higher magistrates court for some time. I'm a retired honorary magistrate, and there is a victim, a forgotten victim in family judiciary, namely the child. Most of the time the focus is on the parents, but the child is forgotten, is hidden. He's the hidden victim of separations and divorces. And the reason why I still speak out is to denounce that victimization of the children. So hearing the voice of the child and thinking about parental alienation is indeed a very complex and difficult issue that embarrasses, so to speak, most family court judges. So the child narrative, the word of the child, and parental alienation is a tricky issue for many family court judges, even though these are the two most rewarding aspects of the job. You know that in the context of conflictual separation or even a situation of parental alienation, the courts rules on the basis of the elements brought to their attention, and the opinion of the child gathered during the hearing is one of these elements. The child is a discerning person, and so the judge has often to listen to the child's opinion. From the moment the family court judge I'm using the acronym in French, the JAF. The JAF is the family court judge. So from the moment the family court judges participate in manifestation of this element, it is up to him or her to ensure that the child's word is obtained in the best possible conditions, that it is an exact, complete and objective reflection of the child feelings, and that the hearing of the child is detached from any influence that any of his or her parents may have on him or her. So that's the theory of a hearing. But in practice, the child's right to speak is not without question, particularly in situations of parental alienation. The process of hearing the child is in fact very fragile. Practitioners always have to find the balance between the respect for the children's right to speak and the necessary protection of which the child must be object. And because in parental separation there may be situations of high conflictual relationships between the parents. So how to find the right balance between this right for the child to speak and the protection of the child. So here I could refer to International Convention on the Rights of the Child of the 20th of November 1989. The Article 12 of this so-called New York Convention establishes the right of every minor capable of forming his or her own views to be heard in any judicial or administrative proceedings affecting him or her, either directly or through a representative or an appropriate body. So that's Article 12. And France ratified this convention in 1990. And so this convention is now enforced in France. Today we are in Brussels, so let me also say a few words about the recommendations put forward by the ministers of the Council of Europe. In 2010, the Committee of Ministers of the Council of Europe unveiled its guidelines on child-friendly family justice. So there are very interesting recommendations. I really recommend you to have a look at those recommendations. They are often forgotten, unfortunately. So let me highlight a couple of those recommendations. The Committee of Ministers in particular emphasizes the best interest of the child, or the right of the child to participate in the proceedings, to be informed of his or her rights, and to have an appropriate access to justice. The Council of Europe calls for a special effort to be made to train professionals, and that's important, and also that a special effort to be made to adopt a multidisciplinary approach. Last but not least, the Council says that the right to be heard and to express one's view is proclaimed as a right of the child, not a duty. And it holds that the children's testimony should be received in a manner that is conducted by qualified professionals. Furthermore, in 2011, the European Commission launched a program for the rights of the child. It's recalled in particular that the rights of the child are fundamental rights. Every state must ensure that these rights are protected and that the best interests of the child guide its actions. In particular, a more child-friendly justice system must ensure that children's rights are taken into account whenever they come into contact with the judicial system, when their parents divorce or disagree about custody arrangements. And the European Commission suggests that consideration be given to the establishment of a specialized judges and lawyers for children. So, how to integrate Article 12 of the New York Convention and the recommendations of the Council of Europe into the French law? There are some legal provisions in France, and so you can find some articles in the Civil Code, but true to say that those articles are not very detailed, and a great deal of latitude is left to each family court judge to set up the system that he or she considers to be the most protective for the child. And so this great deal of latitude means that each JAF, so each family court judge, has its own way of working. So depending on the court you attend, you might have different proceedings, different ways of implementing those principles enshrined in the New York Convention and in the French law articles. So that's a reality. So the judge has a great margin of maneuver. The family court judge must ensure that the child has been informed of his or her right to be heard and to be assisted by a lawyer. the child is a subject of law. So the child should be a discerning child without any particular form. Some judge will say that a discerning child should be 8 or should be 10 at least or 12 at least. And in this, against this background, there is a case law that is often forgotten in the case of an acute coupled dispute. The consent to protect the child from the parental conflict may justify the refusal by the judge of the request for a hearing made by one of the parents. So the hearing can be rejected by the judge from the moment he considers that the conflict between the two parents is too intensive, and this intensity of the conflict between the parents might disturb the hearing of the child, even though it is a discerning child. So this is a ruling by the Supreme Court in France, and I think that 90% of the family judges in France have never heard about this ruling. It should be noted that the conditions under which the judge hears the child are not subject to a precise legal framework. It's up to each judge to determine, in the light of the circumstances of the case, which specific arrangements for the hearing are most suitable. Most children, in this case, will be accompanied by a lawyer, by a solicitor. Whenever there is a child hearing, there should be some writing about what was said during that hearing. It's not really; these are not really minutes, but it's rather a kind of a note-taking that is then passed on to the lawyers. And so the idea here is to respect the right to speak of the child, but also to protect the child. How to protect the child from the moment the child has a few things to say, and if he says a few things that are negative about his or her parents, we should make sure that the child doesn't become the victim of violence, of retaliation by one of his parents due to what the child said during the hearing. So collecting the child's views is a major advancement because the child is a subject of law, but there are some risks entailed in the hearing of the child, and those risks bear some potential hazards for the child. So there is a need to think about the best interest of the child, but during the hearing the child becomes kind of a referee, the one who will influence the ruling made by the judge. The judge will probably rely on the child's views to make up his mind and to issue a ruling. So against this issue of the hearing of the child, what kind of attitude do family judges have? Generally speaking, the judge himself or herself will hear the child directly. And in line with the civil code, some judges will delegate the hearing to a third party. He can do so to an expert in medical or psychomedical matters. The third party that is doing this hearing will be paid 50 euros. Do you really believe that as part of an intense conflict between parents, a good hearing can be carried out in 50 euros? That's not serious, frankly speaking. How can a hearing be made in good conditions for the child when the expert is paid 50 euros only? The hearing can be done through a social investigation also, and there is also the child's condition. What does that mean? It means that the family court judge and a third party, a psychologist, a family mediator, a third party who is quite aware of child psychology, two experts, in other words, will all look at the condition of the child. And this practice was rewarded by the Council of Europe and by the European Commission. It was given the award of the second prize at the Crystal Scales of Justice Prize, rewarding innovative practice. The co-hearing, because that's the name that is given to this procedure, the co-hearing allows the minor to know the family court judge who deals with the case, and the latter to know the entirety of the child's words, unlike the collection of the word by a third party only. So co-hearing allows for teamwork that takes advantage of the values and experience of each profession and restores a form of collegiality. So it's very important that the child is heard not only by a judge, but also by a third party. Finally, the child can be heard. Finally, the child can be heard in the framework of a family mediation process for which the parents have accepted the measure. So, in the face of parental alienation, let me focus on 5 major issues. Discernment of the child. That's the most sensitive subject, which for the moment is not defined by the law and is not satisfactory. Depending on the judge, the practice will vary a lot. Again, discernment is not a matter of age. The Supreme Court has issued 2 rulings in that sense. In a first ruling, the Court of Cassation censored the decision of the Court of Appeal, which limited itself to referring to the age of minor, 9 years, without explaining in what way the latter was not capable of discernment. So, of course, the child is not heard, but it's not a matter of age. And in a second ruling about the discernment of a child, and this is an interesting case, a Court of Appeal had noted that the child, who was not yet 9 years old, and the country letters she had written at intervals of a few days showed that this child was subject to pressure from her parents, and this was enough to verify or to confirm the absence of discernment. So various elements can determine whether the child is a discerning one or not. So, and also to make sure that the hearing is taking place in an objective way. A judge should always ask him or herself what is the degree of freedom of the child. The judge should look at the freedom of the child as part of the possibility of parental alienation, and also to wonder what is the usefulness of the measure. So, in particular, if his point of view has already been taken into account by means of some medical psychological examination of social inquiry. Unfortunately, judges are entangled in qualitative requirements, and they can hardly do qualitative work. It is important, however, not to lose sight of the fact that the children's freedom can also find expression in the fact of refusing to be heard, or keeping silent, or changing one's mind. So much for discernment. The second issue in children's hearing is the lack of training for family judges and lawyers. I'm retired now, so I'm free to say whatever I want. So without elaborating on them, too many practices are ethically unacceptable and do harm the notion of the best interest of the child. So some practices are harmful in terms of the best interest of the child, because family judges are not properly trained. So the judge will ask the child, why don't you want to go and live with your father? Why do you want to go and live with your mothers? Well, these are questions that date back to the 19th century. Gathering the child's narrative, the child's views, especially in situations of parental alienation, is not an easy task and requires development of both technical and relational skills. In particular, this exercise requires professional skills on the psychic development of the child. The judge, like the solicitor, the lawyer, is essentially a jurist, a lawyer, so he carries out his profession with respect for the human being, but a judge is not omniscient. So is the judge or the lawyer best placed to gather the views of the child in cases of parental alienation or conflict of loyalty? A third issue, I think it would be good to strive for uniformity in the practice of hearing children. This diversity of practice is bad for the child's interest. Some lawyers are doing their task very well, but sometimes the children are instrumentalized. Let me give you two striking examples which will be eye-openers of the harmful aspects of such hearings. First example, first a lawyer who was refused a hearing by a judge because of the child's young age had another lawyer hear the child who wrote a report on several pages. Similarly, another lawyer had a 6-year-old child interviewed by a lawyer prior to the child's application to a family court judge. Such practices are outside the code of conduct. A fourth issue is the empowerment of parents and the respect of co-parenting. Let me quote one sentence from a report of the Children's Ombudsman, who recalls that adults may hide behind the child's expressed wishes to avoid their own responsibilities or to make their own point. In such situations, it means that children should not be in pole position and parents should be empowered. When listening to the child, and especially in cases of parental alienation, justice stakeholders need to be more vigilant and to take care of the child's best interest. They should ensure that the child's hearing is taking place in safe circumstances. The child should not be an instrument used by parents to take revenge over the other parent. The child is not forgotten in these separations, nor the victim of the ill treatment of some stakeholders. Every child is entitled to co-parenting, and I'm pretty sure that if all professionals did engage to gather the children's narrative and views in the sole best interest of the child, in that case, it could be a tool to combat parental alienation. Last, I would like to recommend all parents to watch the video that we all watched yesterday, because it's a very realistic movie. In the case of video, the alienating parent was the mother. It could equally be the father. But I think that it could be an eye-opener for many parents and make them realize all the harmful consequences their attitude can have on the child. Thank you.
Okay, so thank you, Marc Juston, for this very interesting explication. I think the importance is that if we hear children, that the way we hear children, it's not only hearing, but also listening what they have to say. The next speaker will be Jan James. She's CEO of Good Safety, a non-profit organization in the UK, and also activities outside. She has a lot of experience about the healthcare and the problems with families.
It was not that long ago that citizens living in first world countries were persuaded that tobacco inhalation was not only not dangerous to their health, but was, in fact, healthy. This pervasive disinformation resulted in chronic ill health and incalculable deaths for millions of people around the world. But it wasn't true. It was dangerous propaganda which destroyed lives. We now face another wholesale propaganda campaign which is destroying countless lives and perpetuated by vested financial and ideological interest groups. In this instance, it starts with the proposition that domestic abuse is a gendered crime, a crime committed overwhelmingly against female victims by male perpetrators. This false assertion has been challenged twice by the UK Statistics Authority based on factual evidence, ONS and police data, yet the sensationalist headlines continue unabated. The legendary Erin Pizzey, a global expert in domestic abuse and founder of Refuge, the first in the world, was ostracized and ejected from the very organization she set up for daring to speak this truth, which was that out of the first 100 women who came through their refuge doors, 62 were as violent than the men they'd left behind. By stating her simple truth, this amazingly courageous and compassionate woman received multiple death threats. Her dog was killed. She was forced to flee the country. Despite her many years saving countless women and children, her incredible legacy and immeasurable contribution to our society has been deliberately smeared and tarnished, libeled and defamed, truth and goodness extinguished. Erin understood this simple fact. Abuse is transgenerational. Those who grow up in violent and dysfunctional households are themselves at risk of becoming either victims or perpetrators. Without therapeutic intervention, the cycle of abuse continues. Tragically, the female support units that she set up to help female abusers were immediately shut down when the new CEO took over the reins, because female perpetrator support units didn't fit the narrative that women should only ever be seen as victims, never as perpetrators. Tragically, for the almost 800,000 male victims of domestic abuse in the UK and their children, the all-female victim narrative is now firmly embedded deep within our collective psyche. And part of this is to deny the reality of parental alienation. Why? Because it's more likely to affect fathers, since mothers are more likely to have the power and control of residency. Yet parental alienation is a non-gendered issue, and the narrative which positions it only as a tool for abusive fathers to re-victimize protective mothers appears as compelling as that of the tobacco industry. Any who question it using facts and evidence can look forward to being attacked on social media. It's no wonder most people remain silent, but within that silence is complicity. Their false narrative enables alienating parents to continue causing serious long-term psychological harm to their children, and paradoxically, ongoing grief and trauma to alienated mothers too. Presumably, their acceptable collateral damage in ensuring parental alienation is not included anywhere within our Domestic Abuse Act, despite being the most brutal form of post-separation abuse to ever befall a safe and loving parent. Have you ever listened to the tragic story of an adult who was forced to relinquish a much-loved parent as a child in order to keep their other parent happy? We have. It's uniquely heartbreaking. Nor is it rare, as suggested by the vocal parental alienation deniers. An independent survey was undertaken on our behalf by the former Deputy Convener for Equality and Human Rights among young people in the Scottish Youth Parliament. A quarter of the respondents stated they'd had to tell one parent they did not love them in order to keep their other parent happy. And according to research by Public Health Wales, parental separation is the most common cause of adverse childhood experiences, commonly known as ACEs. Where the critical level of 4 or more ACEs applied, these children do not have the support of both their parents in 85% of cases. Yet in contrast, for children with no ACEs, 82% of them had the support of both parents. So facts clearly show that children need both safe parents. Tragically, for many children, when their parents' relationship ends, this doesn't happen. In the turmoil of relationship breakdown, some parents' own emotional or psychological state blinds them to their children's needs. A parent's need for continual validation or revenge overrides their focus on the healthy, ongoing needs of their children. And the psychological manipulation of a child, which can quickly lead to the outright rejection of a previously warm, loving relationship with one of their parents, fractures a vital attachment bond and can create an emotional vortex many children never recover from. We've interviewed alienated children survivors, and they all recount a similar and tragic story. As children, they were falsely told that other parent didn't love them, had abandoned them, had left them for a new family, was replacing them with a new baby. These and many other alienating comments made them feel worthless and unloved. They talked about the impact of this while growing up and often referenced years of therapy to overcome their trauma, which may have included suicide ideation, drug and alcohol abuse, low self-esteem, anger and frustration, extreme guilt for seemingly rejecting a safe and loving parent, and trust issues because a parent who they trusted had deceived them. The extreme ideological narrative is one which minimizes the vital role of fathers, yet millennia of evolution, and more specifically, 10 years of robust research by the UK's leading evolutionary anthropologist, Dr. Anna Macon from Oxford University, finds the attachment bond is as strong for fathers as it is for mothers. Evolution has invested heavily in shaping men to be fathers with measurable biological, neurological and physical changes which bond them closely to their children. They provide unique benefits that are of great value not only to their children but to our wider society. Having two safe parents is always in a child's best interest. Both offer a unique additional protective layer to keep their children safe, as do the wider family of loving grandparents, aunts, uncles, cousins on both sides. Yet many good fathers have had false allegations of abuse levelled against them. We can prove it. The Believe All Women mantra results in safe fathers, not only abusive ones, ejected from their family home and the lives of their children. And the biggest problem with this default societal response, when two parents simultaneously claim abuse, it is the fathers who are always rejected. And on more than one occasion, on quite a few in fact, this has resulted in the death of their children because no one believed them. According to serious case reviews, i.e. factual evidence from coroners, more children have actually been killed by mothers than biological fathers. Does this make mothers, like myself, more inherently dangerous to children? Of course not. Most parents of either gender would lay down their lives to protect their children. What it does, however, is shine a bright light on the positioning of safe fathers as a threat and hammers another nail, literally, into the coffins of innocent children who pay the price for this with their life. Here is one of them. His story is the worst we've ever recorded. We've worked with many bereaved parents, and their stories are always tragic. This story, is beyond heartbreaking. He lost his child because no one believed him. When he warned them that his child was in danger, all the alienating behaviours he experienced affect tens of thousands of loving fathers and mothers throughout the UK and throughout the world. Yet Matthew, his family, and most especially beautiful little Archie, were failed by authorities who had a statutory duty to protect them, yet failed. Because it's our collective duty and our moral responsibility to speak out against any narrative which harms people. We need to get our compassion and love and care back into our society. Anything less would be unforgivable.
She controlled who I saw, who I spoke to. She controlled when I saw my family, if I saw my family. I became nothing in this world, and when Archie came along, he was my main priority, and he was the reason why I stayed with her, because I didn't want him to grow up without me in his life. My name was on the birth certificate. We had registered him, and it was the happiest day of actually holding him and being there and knowing that this human being, this little vulnerable person, I was there to protect, and my whole life changed when he was born, because of her conditions, I was the main carer for Archie. She told me that I was not allowed to register living at her address. I wasn't allowed to work. She told me unless I earned over £40,000, then I would not be able to work because it would affect her benefits too much. I was not seeing my family. I was nothing at that time apart from there to serve and help Leslie and look after Archie, keep him well, to keep him happy, to keep him healthy, to stimulate him, to be a dad and be there for my son. I did not leave. She threw me out. During that night, she seemed very nice. I thought, I've done something right, okay. She bought a big crate of cider and she had a drink or two with me, and then she kept giving me more and more. Then all of a sudden, it changed. She tried to have an argument. She started shouting. Archie started crying after I'd put him down. She got up, went upstairs. I picked up Archie to calm him down, to cuddle him, to comfort him. As soon as I held him, he cuddled to me and relaxed. Then I turned around and saw her with the baseball bat, and she saw Archie, and that's when she went back upstairs. I now know that she went upstairs to phone the police and to get me taken away. A police officer came to me, told me to give them Archie. I explained that what happened to them. They still took him off me. They then told me to leave the area. It is a one-sided statement that was given to the police. It does feel like it was a setup. She allowed me contact, and I was having a lot of contact up until the time when I removed my computer. And then all of a sudden, she stopped the contact. It was almost overnight. I had a meeting with Kafkas. There was allegations of domestic violence. I was subjected to having to prove that I wasn't. And once allegations have been made, for people to say, are they true or aren't they? One of the allegations was that I was an alcoholic, that I was a drug user. I had to have hair follicle samples and blood samples taken, and they all came back negative. Apart from my solicitor, I'd never had any involvement with Kafkas, social services, the police, the school. None of them asked my side. The court proceedings ended up that Archie was to spend 3 days with me per week, have overnight contact and be with me. I was overjoyed that my son, for approximately half the week, was going to be with me. And those 3 days, every week, week in, week out, were special days, because I had lost my son and he was back in my life. And we did so many things. Every week we went swimming, every week we went to different tourist attractions, every week there were smiles and happy memories being made. She didn't adhere to the court order. She breached it quite regularly, and there seemed to be no repercussion for her. Archie quite often asked me, why don't I hate his mum? And I would say, why would I hate your mum? And he would reply, well, mummy hates you, why don't you hate her? And my comment back to him would always be, me and mummy made you, and I love you, so how can I hate somebody that made you? She used to tell Archie there's a monster in her shed, and the monster was called Daddy. It is in documents which the council have produced, Archie is scared of the monster in the shed. It's clear that she is if Leslie reported them, it would be investigated. If she found out that I'd reported those concerns, there would be punishment for Archie and punishment for me. Even though we went together, she had this control where she threatened if I didn't follow her rules, then I would not see Archie. I started noticing bruises in not regular places, like under his armpit and on the inside of his legs. I asked him, how did you get that bruise? And quite often he'd say, I ran into a door and Mummy hit me. I took photos of them, and it seemed to happen every week, different bruises in different areas appearing. He came to mind the one week, and there was bruises on the inside of his one leg, and they looked equally spaced and almost like a handprint where somebody had clenched it. And I asked him how he got those, and he told me that Mummy had held him upside down and shook him. Social services, when I told them about that, not interested. They don't look into individual reports. I don't believe that she truly loved Archie. I think that she had Archie as a way to make money. And when it came to the last court case, there was possibility that Archie would have been removed from her care, but in my care, and she would have lost the child benefit and everything else. There were several letters that she wrote. They concluded that she had wrote them possibly 2-3 weeks before, not after she had murdered him. There was letters addressed to myself, to her 2 other children, to her on-off boyfriend, and to Archie. This isn't someone that accidentally killed their son. This is somebody that premeditated, murdered their son in cold blood. They murdered a helpless young boy. They murdered a beautiful boy, all for their own selfish gain. It's changed my life forever. And the only one good thing that has come out of her, she can't hurt him anymore. She can't hurt him.
I done it, Daddy.
now I can present two people who built some sort of a dream team in Germany. This is the family judge, Alexander Erbart, and this is the psychologist, Sylvia Danowski-Ritz. 2 years ago, they met each other and they found out that they want to work and they are able to work to prevent exactly what we've seen now. So they will tell you about their cooperation, the way they work with parents, and the way they don't prolong procedures, and they are really, they are just in the best interest of children. They know the law, they know the needs of the children, and the difference between these two and other professionals, they put it in practice. They immediately put it in.
Live the separation of their parents at every stage of their development. It's always something new. So they will stay with that separation throughout their lives. This is why Vandenstein and Louise drew the conclusion, the following conclusion. Children that have gone through a separation, and the microphone has gone off. There is no sound. The interpreters have no sound.
Nicht? Doch? Ja. Setzen also die
Okay, so I was saying that children need parents to show empathy, but parents being in a conflicting situation because of their separation, before of their divorce, show less empathy to their children. And that is precisely when they approach us. And children need empathy from their parents, and they are faced with the country. And in Germany, we have children homes, we have institutions for children, and there is an institution in Munich where they undertook a study about these institutions for children, and they have realized that most of the time the situation is a disaster. From 1 to 5 years, children are not respected, their rights are not respected, they are not well taken care of. So that is the situation in Germany. But I do not know how it is like in the other countries. But talking about children victims of separation or divorce find themselves in an even worse situation, whereas these children need at that specific moment a regular contact, somebody that really takes into consideration their needs and rights, and this is not at all covered or taken care of in these institutions. I would like now to talk about Tjungars Bormann and Luhmann, two German sociologists who have laid theoretical foundations that we use in our approach. I will start with Tjungars Luhmann, a sociologist and a psychologist of Bielefeld. He is a well-known person, even if my son, who studies in the United States, told me that he's not even known in his own country. So that's quite surprising. Maybe I will contribute to make him more known by talking about him here in Brussels. So he says that the law builds conflicts that can be solved using the law only. So that means that we can give a legal advice to parents saying, okay, from Friday at 6 till the next Sunday, at 6, you will have your child. Okay, that's a solution, but that does not solve the problem of parents, because why are parents having a conflict? Well, that has nothing to do with the law. This is why the law itself cannot solve that problem. This is why psychology is of essence here as well. Habermas and Luhmann undertook a joint study, and Habermas speaks about communicative action. He says that the social community is the community of family bonds, and if the sociological community is dealt with in a strictly legal framework, the conflicts cannot be solved, and other conflicts will emerge because the people concerned use the legal solution as a basis, and they enter into an additional conflict because of that. For example, a decision taken to see the child from Friday to Sunday, and then is the child ill, or if you're arriving too late, you're arriving too early, the transition hasn't been smooth, etc. So that solution, that legal solution, becomes a source of conflict. So law is not the right tool and instrument to solve that kind of conflict. So that is absolutely obvious. And Janice James, I would like to mention her. She quotes a father who said, I have spent 300,000 euros in court. There is a wonderful final decision that has been made, but my partner doesn't take that decision into account. So the court has its limitations. The court itself cannot solve that specific problem. And the law can't either. It is not possible. So this is actually the starting point of our theoretical work. This is the very basis of our collaboration. So let's move to practical examples about that theoretical framework that I have just explained. So we are trying to have parents understand that theoretical approach, these theoretical foundations, saying, okay, so of course we need to speak in clear terms, and we say, okay, as a court, as a judge, we cannot help you. So you have knocked on the wrong door. Nonetheless, we say, okay, we're going to support you, and it's good that you've approached us, but we are not the right person to give you the right solution. But what you want now, you want to be supported. You need to be helped. And there is a will to be helped, to be supported. Okay, we can do that, providing you put aside your parental conflict. And the French colleague also mentioned that at the end of his presentation, he said that hearing the child is not a solution per se. In what you said that the child can be instrumentalized, can be alienated. So that's why we do not mention the child, because the problems faced by the child are not problems of children. These problems are triggered by the parents. So first and foremost, parents have to solve their conflict, and then the child will get better. So this is a golden rule for us. Don't send a child to a psychologist. Send parents to a mediator. Of course, children may need to be psychologically supported as well, but this is not the key solution. So parents have to solve their conflicts first. Otherwise, the child will see a psychologist. It is as if the child had a broken leg, and with a plaster, and you keep breaking his leg. So parents have to solve their problems first, and So parents first have to solve their conflicts before sending a child to a psychologist or whatever. So that's really what I'm trying to do. I'm trying to convince parents to go down that road, because there are still a lot of prejudices about psychologists. People will say, I'm not sick, I don't need a psychologist, I am an intelligent person, I know what I do, I don't need to go through a therapy. So that is what we hear. But actually, when they come to us, that means that they haven't succeeded and that they need the help of professionals. And this is the right time to convince parents. And this is very rewarding for me to hear such things. And the court is not useless either. The legal procedure can contribute to the finding a solution. As to parental rights, the right of visit of the child, the parental custody, indeed there are procedures about decisions to be made about alimonies. And if a child is threatened, if the safety of a child is threatened, we have the possibility to find solutions. For example, stopping the contact with a child for a certain period of time. So these are things that we can apply. So we will, of course, introduce a legal procedure. The child, of course, has been heard. He may say, I'm not interested in seeing my mother, I don't want to see her. The child in question was 14 years old, and in that case the contact was stopped for 10 years.
So, however, we managed to convince the mother to do some psychotherapeutic work. The child will also benefit from this psychological work to enable him to meet his mother. So this is something that we have put in place together with their lawyers. It's a way to provide support to the child. And so they tell the parent, now you don't have the choice. And even if the child doesn't want to see his parents, we told the child that he has no choice this time, because he has this support, this framework that is put in place. It is very important for the child to maintain the contact with both parents. So, so sometimes the child is not a discerning one, and that's the reason why we take the lead, and we tell the child, you must go and see your parent. Also, when we realize that the child is under threat, in that case, of course, we can foresee some measures that will put an end to those visits and contacts. I don't know how it goes in your country about the money that is paid to experts. In my country, we have good rates, good fees for experts, and the state is not really keen on having too much expert work because it costs an arm and a leg. So in general, half of the cost that parents must bear in the procedure are expert fees, but it's money that is well invested. Well, to pay that, maybe sometimes you have to forget about your holidays and say, okay, we won't go on holidays this year, but it's money that is well used in the best interest of the child. I now come to the success. How can we measure the success of this kind of arrangement? Well, as I said, from time to time, there will be some interactions with the court, but typically the rate of success is around 95 to 98%. Typically, we work with addict parents, might be drug addicts or alcoholic parents. They might have all kind of addictions, and we will immediately tell the parents, you need to realize that our support will not be a therapy. It won't cure you. If you don't take your own fate in your hands, if you don't change your attitude, you will not be able to restore proper contacts with your child. Very often, we try to tell those parents, try and combat your addiction, and then come back to see us and we'll try to find a solution. In the meantime, you may still get in touch with your child by writing a letter or through emails or through Skype. So we try to show parents that there are some ways of maintaining the contact. So once parents are convinced of the need to maintain the contact, the need to accept the kind of support that we offer, then you can be pretty sure that this will be a successful endeavor.
Of course, prevention is key. It's always better to have parents reacting early, but we really have to see to that as well. But unfortunately, youth institutions or other institutions do not always give the support in the right time, at the time when parents and children need it most. So the measures or the support given by the institutions are given within the framework of a legal procedure, and in addition to that, most of the time they don't have the right competences because they fulfill many other tasks as well. I would like to go back to what you were saying, and also to deal with the issue of the issue of expertise to find a solution. A mother that hasn't seen her child for 10 years did not call me just yesterday. There are some protocols, meaning that sometimes I am involved in the right stage for 2 or 3 weeks, and then there are other priorities to set when the contact has been lost, when there is no contact. So I got the mother on the phone. I said, unfortunately, I don't have my diary, but don't worry, we're going to set an appointment. And so first I talk alone with the mother, then with the father alone, then I see the child with the mother. That teenage is 14 years old, then I approach him alone as well. So I do what I call psychoeducation. So I tell the parents what they should provide for the child over the long term. And try to see whether the well-being of the child is threatened or not. If the parents are not ready to receive advice, then I will tell the court, okay, after our information session, parents still behave in the same way. So in that case, we need to go back to the court immediately. And the following hearing takes place just a few days after, so they cannot leave saying they are not interested, because actually we realize that the well-being of the child is threatened, and I am the one warning the court about this or saying that there is such a risk. So in this case, it's a teenage boy of 14 years old, and I told him, you are not forced to remain in touch with the parents in the future, but we are going to hold a meeting. During that meeting, you will be together, and you will be able to say what you want to say, the griefs that you have, and that is compulsory. The judge explains why this is required, and during that mediation, a lot of things are being done. All the appointments before and after are linked to that mediation. So parents know that I want to be to have a seat at the table. It's a requirement. Otherwise, the judge will say, okay, if you don't want her, we will nonetheless designate a third party, an institution, principal of an institution, whatever. So most of the time, parents agree, and this is immediately recorded in the secretariat of the court. And I always say, okay, you can still call me afterwards, and it's important for parents to know that even years after, they can still give me a call. They know that I'm still available. There is something I would like to suggest. I think that should be like that for all procedures, or follow-up, a 1 year follow-up, or follow-up after 1 year. If and there are no more hearings set, I think there should be a follow-up 1 year after with all parties involved, youth institutions, psychologists, lawyers, judges. I think this is absolutely key, and many experts tend to say, well, no, maybe they think that we are questioning what they have done, but this is not the case. I would like this to become a standard. This is what we call the Gratz model. What is also key is multidisciplinary collaboration and long-term training courses, ongoing training courses for all the different experts, for all the parties involved. For example, we have a problem with the youth office or the youth institutions. They feel a bit excluded. So we want to give access to ongoing trainings to all professions involved. So everyone has to know about their roles and must not interfere in the others' fields of expertise. So the youth office will follow a training about youth. The lawyers will do their work, and no one will interfere into the others' jobs. And everyone has their responsibilities, and it is also important at some point in time to acknowledge that you play the evil's role. So what does a family judge do? A family judge has competences in other fields. He may have competences in psychology, knowledge in psychology. For example, a judge knows that it's important not to stop the contact. So the family judge must be up to face his responsibilities, and the judge knows that they may take decisions that are not nice for parents. And so many family judges say, this is too tiring, also I already have so much work. Then I say, why have you designated me as an expert if you don't want to see me? So there must be equal footing between the different professions, between these different competencies and qualifications. It would be great if we could always speak to one another on the phone. It doesn't always work that well. It always goes through him, but that's okay. Nonetheless, it is quite smooth. So that's what I wanted to say about our method. Have you talked about the success rate? Would anyone like to raise a question? Do we still have time? Well, I would just like to mention something I forgot to tell you. Actually, we encourage parents, we motivate parents, go down that road, do that, be positive. This is the only way you will find a way out, or this is the best way to find a way out. So we are very positive in how we communicate with parents. We want parents to feel that they are in a positive environment. and we are positive. We say we have a solution. We will solve your problem with you. So we are always positive. Our approach is always positive. So we always tell parents, you need to trust us, and you can be sure that if you are positive as well, we will find a way out. About difficult cases, psychological abuse of children. That's how I call it. So psychological abuse of children. In that case, it is the judge that will set the framework, and we are able to take children out of that situation, and we do it when necessary. If the behaviors of parents are abusive, or if we think that there is a risk of violence, we face up with our responsibilities, and we may ask the child to take part in the court procedure, and we may indeed make the decision to send the child to the competent, to the relevant services. And that is when my work starts in that case. And my recommendation is decisive. When I ring the bell, when I say, when I send a warning or a red signal, there is always a reaction. We always take an action in the interest of the children.
Is really what also is working. So right now we are coming to the first end of this morning. We are going to have a pause of 15 minutes, and then we'll be back. Thank you. Okay, so we're starting the next part of this morning. The next speaker is Marie-France Carlier. She's a judge, family judge and juvenile judge in the arrondissement of Dinant in Belgium. She has done great work, and she's going to explain how and making a difference for children and families.
Hello. So good morning everyone. I don't know what to start with. I was very pleased this morning to see Alexander so passionate. I think that we are all here together precisely to create bridges, in exchange, to try and convince those judges who are not with us that it was a shame for them not to be with us, to improve their working methods. We heard in some presentations yesterday that some people believe that it is because of the inexperience of some judges, it is because of the aggressiveness of some lawyers that parents are separated from their children. So some imagine that in a couple of years from now there will not be any family courts anymore. Is our job meant to disappear? I don't think so. But the kind of hearing room that you see there doesn't suit a family hearing. Sorry, I have some problems with this device. So I invite you all, not just the minister, I invite you all to come to my town, Dinan. This is a bit more friendly. I think that the judge should sit on the chair at the same level as the parents. We are close to each other. You can see the emotions on the face of the lawyers, of the parents, and even though everybody is wearing a mask, you can still read some feelings in the eyes of the parents and the children. I hope that in the near future we can do without masks, but I think that this is a proper setting for a family hearing. It's going to be all right. Don't worry. So some tools are there to help us, the legal framework, and we are lucky in Belgium because we have many laws that support our work and that support shared parenting. In Dinan, my town, we have adjusted this model. We call this the parental consensus model. I could have invited some parents here. The Dinan Bar is working in cooperation with me. I have several experts here in the room who could stand by my side here because we work all together in order to empower parents and to bring them to find the best possible solution in the best interest of their children. So I will quickly review the different tools that we have. The minister already mentioned them yesterday, so I will skip this. So we have a set of very nice laws. The law on equal accommodation is very good. I would get rid of some wording, but I agree with somebody who said yesterday that thanks to this law, there are far less conflicts during the hearings. Today, the solicitors, the lawyers hesitate before objecting equal accommodation when all the parental skills are there and when both parents are, should I say, available. Well, no, but because having a job is not an excuse for not getting access to this equal accommodation, but when they have all that is necessary to accommodate their children. I would like to dwell at length on the law of July 2013 that created the family courts with specialized judges. We are trained, we have a certification. Of course, the training can always be improved, but we are specialized. More importantly, you can choose to be a family judge. You know that in courts, the last to arrive doesn't have a choice. So the last in has not first choice in the kind of a position he or she can take within the court. So I think becoming a family judge should always be a choice, a deliberate choice. This law has also fostered alternative ways of conflict resolution. It has also improved the finding of solutions. The amicable settlement chambers have been created. In fact, this is not a judge, but it is somebody who will tell the parents, well, if you go to the court, you can be sure that the court will take that ruling, so you will have to pay at least 150 euros because we have a specific calculation method in Belgium whereby you have to pay that amount. So they prefer to have this amicable settlement. rather than pay for their ruling. The law also simplifies and fastens the procedure. The requests can be addressed within 2 weeks. What it really matters is that for the first hearing, even you have to wait for 3 weeks to 1 month, it is important for the judge to be able to meet those children who have requested to meet the judge. In the family law in Belgium, it is said that all children above 12 years will receive a letter saying that they are allowed to see the judge, and that they will get a reply within 5 days. So either they can call the court or they can send an email. So children who want to meet the judge can do so, and those who don't can do so also. So, and of course the request put forward by the child can be rejected by the judge when he or she believes that there is some parental manipulation behind this. My favorite law is that of June the 15th, 2018, that you can see here. So in family matters, when both parties come to the hearing, the judge can ask them, what have you done before coming to the court? So you cannot enter the premises before talking to the other party. It's legally binding to ask parents, what have you done before coming to the court? Have you tried mediation? Have you tried the amicable settlement procedure? Have you at least organized a meeting between the two of you? My point is not completed because in June 2018 we can activate mediation when only one party calls for it. We would strongly advise both parties to go to the mediation, and of course the other party thinks that if they don't agree to go to mediation, the judge might be influenced and rule in favor of the other one. So we fix a date for this mediation, and parents dare not cancel the first mediation meeting. It's the same for expertise. I like to set a date, and I tell the parents, you don't choose the first date. After that, you can fix the date together with the expert. Why, in spite of all those laws, which are pretty good and pretty helpful, why, in spite of a quick treatment of the case, why a strong incitement for both parties to accept the process? Why are there still families that break out? Because a judge is there to rule on conflicts. And this is something that you need to explain to people. And if the judge is alone in his speech and is not supported by the lawyers of both parties, the ruling will not be respected, will not be abidden by. And the procedure as it stands now is still a for-against procedure. When you are quoted, when you are asked to come to the court, this is quite aggressive. This is something you must do. You must go to the court because you get a notification to do so. So the solution we came up with in my city, in Dinan, is the so-called parental consensus model, which means that we all have to work together. And I like very much this picture, because if we don't row together at the same time, we will capsize. So it's important that all stakeholders have the same narrative vis-à-vis parents, that we all have the same behavior vis-à-vis parents, and that we support parents in the right decision to make. I won't come back on the COSHEM model. This is an interdisciplinary fast-track model that empowers all the stakeholders, that makes them responsible about the interest and the needs of the child. It is known as the best preventive model against parental alienation. So I will really skip all those pictures. You see that it's not by chance. The two cities are pretty similar, as you can see, Cochem and Dinan. Where does this tribunal or court approach stem from? Again, it's a contradictory procedure. Don't believe that you go to the court to win the child. No, you go to the court to become co-parents, empowered co-parents. We should put an end to never-ending proceedings. During the first hearing, I tell the lawyers that it is impossible to postpone the case, except in exceptional cases. So both parties have to show up in person. If both parties don't show up during the hearing, if the demanding party doesn't show up, we can reject the request. And if the other party is not there, we can sanction the other party by default. So, a proceeding at the service of the people, we have a simplified request. The COSHEM request is a tick-the-box system. Let me show you something that doesn't exist in the other jurisdiction in Belgium. So I will go very fast here. The modalities try to empower the parents. What have you done? Why is it so that you are not in contact with the child? The motives. We want transparency. We want everything to be clear, transparent. We don't want any parent to be named and shamed. This is something that doesn't exist in the other jurisdictions. That's what we've added to the request. It is a little box for the prosecutor. You see that there is a box there saying there is a suspicion of parental alienation or worrying disruption of the ties. And so we asked the prosecutor's office to help us. And you see that under other, it could be said here, the father hasn't seen his children for so many weeks or months, or the mother hasn't seen her children for so many weeks or months. And so we will ask the prosecutor's office to attend the hearing. And the prosecutor's office will there to defend the rights of the child during the hearing. Let me come back a couple of slides before. Everybody tells me you don't like conclusions. Well, I must say that before the first hearing, I want as little to be written down as possible. So please, solicitors, writing your requests is quite a lot of work. Come to the hearing and let's start from scratch. The first hearing is a place where everything comes into play. That's where we will try and guide parents. So we have template agreements in the waiting room, and the lawyers will receive some time to discuss among themselves before entering the hearing room and see what are the points on which they, or items upon which they agree and disagree. What are the possibilities foreseen in the proceedings? Well, you can have a full agreement, but you can have full agreement and not be able to express them. Because to have a full agreement means that you close all the doors and people come back 3 months later because they were not able to manage their own full agreement, which means that they did not resolve their conflict. A conflict is everything that is not said. It is all the anger, the sadness that is not expressed. When parents have not sorted out their conflict, well, an agreement will not deliver at the end of the day. So I will either ask them to go to the mediation or to communication workshops for separated parents, where they will have the possibility to talk to each other and really get rid of all those conflict issues. When the ties are disrupted, you need to act fast. And I will try to get as fast as possible an agreement from both parents to resort to an expert. And I will say a few words about collaborative expertise, because I have the creator of this innovative expertise here. So workshops, communication workshop for separated parents. These are evenings, group of 15 people gather to discuss 3 themes: the shock caused by separation, the way children have experienced this separation, and the impact of the in-laws. And parents who have attended those workshops all say that it was a very fruitful experience that faced them with their reality. My role here and today is to tell you more about the role of the judge in this parental consensus model. The law tells us that our main task is to reconcile both parties. If there is an issue upon which they disagree, we need to find an agreement during the hearing. All the professionals should be part of the same momentum, of the same approach. We try to come up with solutions, and we always manage to reach an agreement. Very seldomly, no agreement is reached, and parents are quite pleased that there is an agreement, and we can tell parents, okay, maybe the mother is not really pleased with the idea that the father will have 50% of the accommodation time. She's a bit afraid of that. You will tell the mother, okay, we understand that, but let's try and see in 3 months from now whether the father is able to take care of his children. What is very important is the serenity of the debate. It is very important that no parent is named or shamed, and the solicitors know it. I don't accept any lawyer or any solicitor to name and shame or to vilify the other parent. They can say, my client fears this, is afraid of that. The father has problems with alcohol, so the mother fears that the father could continue to drink at night in the evenings. This is something we can discuss during the hearing. Always refocus the discussions on the child's interest. The family story is, well, important, but what is more important for me is the future of the child. We know that Mr. left for the neighbor. What's the point in repeating the same story over and over again? What matters is that the child has a good experience of this separation. And what is important for Mr. to understand that this is a bit difficult to live for Madam. What happens when a parent doesn't cooperate? Well, that parent should know that I will not accept this. I think that the role of the judge is to provide a framework and to be very strict and authoritative when needed. So in case the ties are disrupted, I always convene the hearing in the short term, on short notice. Well, we will simply check during the hearing whether the parent did attend the collaborative consensus meeting, whether he respected all the appointments. And so I will have a hearing right after this consensual methodology appointment to make sure and to check whether the parent did attend that appointment. During the first hearing, lawyers have a very important role to play. When the ties are disrupted, we will resort to collaborative expertise. And typically, lawyers are familiar with this procedure. They like it. They have worked with this modality in the past. So they really prepare the ground to such an extent that my work during the hearing boils down to almost nothing. True to say that many parents come to the court without any lawyer, and then I have to explain them how things will develop in the future. Then, in the ruling, you should be short. The more you put in your ruling, the more substance you give to appeal. So it's a loss of time. So you should simply try and prompt parties to work together and to restore the ties of the dialogue. A couple of words about the expertise based on parental collaboration. I could have asked some experts here in the room to join me on the rostrum. This expertise, in fact, is due to the realization of the unsatisfactory outcomes of mainstream expertise. What is the aim of this expertise? To rebuild the links, to rebuild the ties. Ties were disrupted, and this is unacceptable. Of course, it is difficult. There might be some relational difficulties that pre-existed the separation. Yet, we should try and work on those issues, because there is the right for each parent to remain in touch with his children or her children. So the size of those contacts will depend on the size of the relational difficulties that do exist and depend on the year of the child. This requires good collaboration between all the stakeholders, so the church, the lawyers, the experts, as well as the real cooperation of parents, and that's where lawyers have a very important role to play. There's no point in going to the expertise if parents don't believe in it, if they are not ready to engage and to commit themselves to this expertise. And if parents don't do so, a lawyer can ask the judge to remind the parent of that duty to go to the expertise and to fully cooperate. In Dinant, since the very inception, we have set up a multidisciplinary team. This was initiated in Mari-Burkina, and we are talking all together. All the stakeholders are invited. So we have the youth assistant office, the youth protection service, the justice house, the family planning centers, and we are all on equal footing. No one takes precedence over the others. So there is no primus inter pares. We are all on the same level. And it's a way for each and every one to get to know the others pretty well. And they know what are the rules of the game when they go to the family court. So they know the rules of the game. So all the stakeholders know each other pretty well. We organize debates and information sessions about this collaborative cooperation, collaborative system. We can ask any of those stakeholders to come and identify the various problems met in this process. We can also invite foreign experts. Of course, we had to put this on hold for 1 year due to the COVID crisis. We invited Lorraine Fillon from Montreal, and she was quite instrumental in putting up those communication workshops. How could we further improve the efficiency of justice in Belgium? I say and keep saying that we should all work on the same track for the benefit of the child. So what can be done to further improve justice? Well, we could foresee an awareness-raising session for parents before the first hearing. Yes, I forgot to tell you that before any hearing, I talked to the lawyers, and before the COVID, everybody would come, parents and lawyers. And this is in good mood, with a good sense of humor. I remind them what mediation is. I remind them of the difference between a conflict and a dispute. I often quote Marc Gestion about mediation. I also refer to the various tools that we have for mediation. I also give them information about conferences. I tell them how to file their case. I inform them about the proceedings, the methodology, how alimonies are calculated on the basis of a program, a software. So even the lawyers can do a simulation to calculate the alimonies. Together with Olivier, we would like to implement the contact facilitate mechanism that exists in Germany, which means that the prosecutor's office can send an expert, a contact facilitate. This is something that we are currently discussing with the minister. Of course, this entails a cost. We need to pay those experts. And in Belgium, we don't have so much money for justice. The gratis pro deo proceedings is only available for people with a basic income. Experts are not as expensive in Belgium as in Germany. So we need to make sure that all professionals are aware of their responsibilities. The mediators, the lawyers, we all are on the same boat, and we all have a pretty heavy responsibility on our shoulders. It is very important to pull our socks up and to take daring decisions, to take easy decisions. An agreement is an easy decision. Is different from taking a harsh decision, for instance, to change the accommodation of the child. This is not something that is often requested to me, but this is kind of a harsh decision. To put a financial sanction on one of the parents is not easy either. When there is no show of the child by one parent, then you have to put a fine to prevent this from happening again. So judges have pretty heavy responsibilities. he or she's the one who has to create the momentum for an interdisciplinary work. The judge has to take the lead to tell the lawyers, this is how we work here. No matter whether those lawyers come from Brussels or lawyer or elsewhere, they know that in Dinan the proceedings is as it is, and there is no exception to those rules. And so we invite all the trainees, all the future lawyers to come to Dinan to see how it works. I also wanted to mention Resolution 2079 because we implemented the consensus model in 2012, but since then a resolution was passed unanimously by the Assembly of the Council of Europe that calls upon all parties, the contracting parties, the states in other words, to develop family mediation by fostering multidisciplinary cooperation inspired by the Cochem model. And nobody refers to this article and to this resolution, quite amazingly. I also need to tell you that the same model is now applied in Switzerland. I myself, together with a colleague, went to Switzerland, to Sierre and to Monte, and it is in the Monte jurisdiction that the consensus model was first implemented. So we are prepared to go and travel everywhere in Europe to contribute to the implementation of this model. Some Flemish judges also sent me a letter about this, and so much the better. If other judges in Belgium, in important jurisdictions like Antwerp, want to change the game, they can do so. So everybody's welcome.
Et je suis, voilà, j'improvise. Je suis contente de...
Well, I'm improvising. I'm happy to welcome Mrs. B. Maric. We've been working together since, at least in the implementation of the consensus-based model. But today she's wearing a second hat. She will talk about the role of lawyers. I haven't dwelt on this, and that role is key. And for several years now, she has developed mediation work involving children. We now have 2 mediators in Dinan, B and Mrs. Veronique Skelenkels. And I must say that when family ties are broken down, well, it depends on the extent of the breaking down. But the thing is that judges are not informed about failures of mediation, but actually these 2 persons work so well, so efficiently that there is no failure. I'm just joking, but when there is expertise, we get a feedback and we know why, we know which parent hasn't collaborated. So I would like to congratulate B. Maric to be here today because she gave birth a few weeks ago, and I know that that baby is in the room with us. And that baby will certainly listen carefully to her mom, or his mom. So I will speak about my practice, my practical work. Well, my practice is the same whatever the jurisdictional territory, and my practice actually is consistent with my professional competencies and qualifications. So the tool that I will present to you can be used elsewhere, even in districts where the consensus-based approach is not applied. But of course, it is easier for me when I can do that in the framework explained to you by Mrs. Carlier. So I will talk about the role of lawyers, talking about parental alienation. We have to focus on prevention and mediation work. I would like to thank Jean Van Emelray, who used the metaphor of an umbrella, saying parents, willingly or not, well, they will use an umbrella when it rains, and even if they say so, they always forget to take their umbrella with us, and they are all wet. So what we do is a bit like in Louvain-la-Neuve. Louvain-la-Neuve is a pedestrian city, so the sidewalks are covered. There is a roof, so whether parents forget the umbrella or not, they won't get wet, and their children won't fall ill, they won't get any bronchitis or get a cold. So the lawyer is really looking at respecting the needs of parents, or at least lawyers are realistic, and they're not going to say, okay, that conflict must stop just like that, out of the blue. And actually, we cannot freeze children. We cannot stop their development. Maybe it would be interesting to test such a tool to be able to freeze children, but it's impossible. So children live the conflict when the conflict emerges, and the damages have been well detailed by professionals, other professionals. So this is the background of what I do. We are well aware of the fact that it is difficult to overcome their problems. We are not judgmental with the parents, and on the other hand, we cannot negotiate the protection of children. We may say, okay, that sidewalk which is covered, you may not like it, you don't like that city, but don't forget you can still use an umbrella. So we will support you, we will help you find your own solution. So this is what I show when I make an introduction about the consensus model. So the need to deliver a quick and early sentencing or legal decision, because I usually don't hear people telling me, let me suffer, I am being insulted all the time, that's great. So I don't have that kind of clients or patients, or I do not meet these people. These are not the people that approach me. When they approach me, it's because they are fed up, they are frightened to lose their children, to be financially dependent, they are not clear about their rights, and what they're looking for is a professional that will give them responses, and the responses that we're going to give to them are not known to him beforehand. They do not come to us to say, please kill my husband or kill my wife. This is not the kind of parents we receive, and this is not how they approach us. And what I like with the consensus model is that there is very often the courts react quickly, if needed. So we will, the courts will give a first response, will deliver a first decision about the living arrangements. That means that the children will very quickly know where they will live, where they will be accommodated, and what will be the living arrangements with their parents about the housing or the accommodation of children. So we give beforehand information in a confidential interview between the client and the lawyer. And we also draw up a strategy to be clear about the fears. When I say that, talk about the authority, these are lawyers, judges, experts. So the relationship between the lawyer and the client, it is not on the basis of an authoritarian figure, but they approach a judge, they approach an expert, they approach a lawyer. So whether we like it or not, parents feel it as an authority. And some say, okay, I actually a psychologist has told me that my husband is a narcissistic. Well, actually, it has been said with authority, and parents remain with that information, that piece of information. So that's sort of desperate, and so the information we give to them has a weight. Is authoritarian. This is what I call the authority or authoritarian figure. And then beforehand information. It's the professional framework. So actually people are free to change lawyers, but my methodology belongs to me and I explain it to them, and this is not to be negotiated. What I do not negotiate are twofold. That is to pay alimony, children benefits, and the contact with another parent can not be negotiated either. But depending on the cases, maybe we'll have to go through meetings, or we'll have to find arrangements about the kind of contacts that they will have. So these are the two non-negotiable elements, the alimonies, as I've said, and the contact with the parents. The first interview is quite long. Parents actually explain their lives to me, and it may last 1 hour and 30 minutes, but is it possible for me to support them if they haven't received all the information about their rights? Then, when some parents say, I'm not going to give her 1 penny, she won't receive €1. Okay, she left me, I cannot see my children, I am not going to pay anything to her. And then I say, okay, but what about the children? I'm not talking about your ex-wife or whatever. So I take the time to explain. And it is not B. Merrick that says that, it's the law. So my job is not to hammer with the head of my client on a desk. No, my job is to defend his or her interests. So if they want to appeal, they will always find a lawyer. But in any case, even in an appeal court, an alimony has to be paid. That's the way it is. There is one has a higher income than the other, and that's the way it is. So an alimony is due. So why should we take 6 months and go to court to finally get a decision that just states the law, alimony is due? And then about the living arrangements. So as we've said, for these 2 days, if the parent makes the request to see their children, there will be a contact, and that's the law that provides with that. It is not it is optional. They don't have the choice. So and both parents will find the lawyers to fight about this, to set upon that, but it's inevitable. It's the law. So if one of the parents is wants to see their children, that's the law. Sometimes people say, oh, you are a psychologist. No, I am not a psychologist. I just know the law. There must be alimony. There must be a contact if they ask for that. So we, that's part of the judicial code, we have the duty to inform people. Then if they do not agree, then I may sound a bit dictatorial, like a dictator. Then I say the following. Okay, I speak using the words of children. Okay, so if you set upon one another about alimony, here is what's going to happen. If you don't want to pay €1 for your children, okay, during the hearing, you will be considered as a bad parent. you are at risk at being considered as not willing to take care of your children. The hearing won't be very pleasant because the judges do their job. They say, okay, I'm not asking you to pay to your wife, or I'm not asking the wife to give money to the husband, but your children need to eat. So you have no choice. You are left with no choice. So I prepare clients to that. And then if I say, okay, if you stick to something that will not happen, that is not paying anything, that is not possible. If you still want that, well, change lawyer, because I'm not here to tell you lies. So if you don't want to change lawyer, then I can adapt my fees. I am known to apply low fees. But then if you ask me to do such a work and to be detrimental to you and it's not part of my job, it will be time consuming, energy consuming. You are asking me to do a bad job, and that has a cost. So if you really want to keep me as a lawyer, and if you really want to keep me and ask me to find a way that you won't have to pay your wife for the children, okay, then I will triple my fees. And as to the living arrangements, it's the same. In my cliches, the husband didn't want to pay, and the mother didn't want any living arrangements. The son has gone off. The son has gone off.
Ah, non, ça va, il revit. Il dit OK, 3 fois.
Okay, so it works again. Probably because I proposed to pay 3 times more. So, well, actually, the case of a little boy who is 5 years old, and the wife says, well, he doesn't, the father does not even know the name of the pediatrician, and now he wants an equal living arrangements. Well, that's the way it is. Before, you are not divorced, separated. Now he's asking for that. That's the law. He's the father. It's important for the child, whether you like it or not. And of course, there are many other things that are being done with the suffering mother. I do respect the suffering, but that's something I do not negotiate. She can negotiate with another lawyer. And I know plenty of colleagues who would like to do that, who like to do that. Who like to work on conflicts. So I tell them that actually they may be considered as alienating their children. The hearing won't go well, that a parent will be blamed for triggering the breaking down of ties. So even before I have to list all this, parents tend to understand. I remember once a client who had ticked every box, and another one who paid 3 times more and finally said, you were right. So this cannot be negotiated, cannot be questioned. And actually many colleagues say this is not our work. And so what's our work then? Then I should not be called a lawyer. My work is not to say that a desperate parent who wants something which goes against the best interest of children, and I should agree with that. And my job is to just repeat what the law states and full stop. What is a bit more complicated and something very frequent with parental alienation dossiers. Most of the time, parental alienation is on the grounds of the fact that a child doesn't want to go to the other parent, or the girl says that she has physical suffering. So there are specific criteria. The husband drinks, or the wife drinks, or the new family is not doing well. And so we behave as as if we didn't hear the fears, and this is not good. So the consensus model is a requirement to be able to receive the fears, to hear objective fears. For example, if there is a fear about the way the child is raised, well, would the parent involved agree to meet a parental coach? And then, actually, in 2 or 3 times, that may be enough. So the parent is supported, that can reassure the other parents. So there are so many tools, but I don't have time to go into the details about these tools. But of course, we need to give a response, and both parents have to collaborate. And I'm sure that you will receive the slides afterwards. But to say that the consensus model is very helpful to be clear about the objective fears. So we establish we actually establish the obligation to keep the contact. This is not to be challenged or negotiable. It is part of the law. So when talking about consensus, people tend to think that it's just something we've fancied, but actually there are colleagues who told me I am a modern lawyer, so I'm not saying anything. I'm not saying that there is a drinking problem. Okay, then, but what should we talk about? We can just play just a few games, but this is. And this is not what the parents are expecting. So that means that the sentence or the legal decision that will be made won't be relevant. So if one of the parents is alcoholic, then I put it down. And we even go to as far as making blood intakes, because actually a judge is not going to encourage alcoholic parents to have the children if they are not able to deal with their children. So there are so many shades of qualification, so many things to say, but fortunately I don't have time to go into each and every detail. Then I remember the case of a bipolar mother and with a child of 2.5 years. So I was talking to that father who accepted to see his child for just 2 hours at a time, and I have in front of me a father which is very clear-sighted and very ready to collaborate. And on a Saturday, I received a text message. He said, "I've just beaten up the mother. My child is here. I've called the ambulance. I need to be helped." So I immediately called the ex-wife. The police was already there. So it's a clear case of violence. The police was called in. And today, we almost have equal living arrangements. So you may think that I'm totally crazy. But no, actually, we are a whole team to support that person. So even if that father is bipolar, he's really willing to collaborate. He is clear about his own problems and difficulties. And so we have the legal decision, and there is transparency. So it is very important to name the difficulties that families are faced with. And so it's very important So we know that third parties can be harmful as well, but in any case, the children have to have a place where they can be supported regarding their fears. Now, the role of the mediator. In prevention, the mediator can propose a broad range of tools, and we will choose the tools that are the most relevant for that given family. And we're talking about standard mediation, but within the standard mediation, I propose tools that respond to specific needs. And in doing so, I act as a lawyer. And I would like to thank Ursula Gronso, who is a model for me. And the children have their say into this. So, with regard to prevention, we have an interview with the family, and there are several possibilities. This applies with young children most of the time. And I apply the game according to Mrs. Koju. It is something I heard about that I have slightly adapted. So the whole family is in the room. We are filled with parents who are respectful, but they are experiencing tensions, which is quite normal for a couple that wants to divorce. And then, while they are walking under the roof of the court, I say, okay, you could actually wear the umbrella that way. In order to make sure you don't forget that umbrella, remember the metaphor, well, you could use it that way. So that's what we do with that game. We will describe how the parents met one another, and they draw, and the parents cannot say anything, and the children love to do that. And that's about it. And actually, the words used by the professional are positive. For example, the mother has taken her heart and she has put it on the heart of another man. And that kind of words and that kind of thing. So we put names on taboos. Then the jeu bonjour, good morning game. So actually the family walks around the room, and the children clap their hands, and when they stop, you just have to say hello to the person next to you. And that's a way to see people are loyal. Actually, children wait for their parents to be as far as possible from one another to make sure they won't greet one another, whereas the other parents wait for their parents to be close to one another to be sure that they will be forced to say hello to one another. Just saying hello allows us to go further. And children start speaking. Remember, I had to say hello to a person in a shop, and I didn't want that. And now you see how it feels when you have to say hello to someone when you don't want it. So we ask questions. What is the favorite meal of daddy? And the child will respond. It's just a game. It's a family quiz. And then the other game, ça dispute ou ça discute. So is there a conflict or a discussion? Okay, so we have a father who is a urologist, and the mother is a medical doctor or a PhD. And okay, then the mother says, no sugar for my children. And the father says, okay, no problem, they can eat grapes even if there is sugar into it. So we have them talk about something they can deal with. We have to make sure that it remains relevant, and children just play with their own games, Legos and others. And then I say, is it a discussion or a conflict or a dispute? And then they respond. And then the parents realize that they were quiet, they were not shouting, they were just adjusting to one another. But for the little girl of 3 years old, it sounded like a dispute, a conflict. And here we're talking about prevention. Now, repair. Ooh, someone is coming. Probably I'm exceeded my time. Mediation about the transfer and the breaking down of ties. When there is an incident, for example, as a lawyer, Mammy didn't want to send her child to the father because there was a major quarreling between the father and his new wife. And then the judge says, okay, there has been one incident. The father acknowledges, there is no denial. We are talking about transparency. It's an isolated, a one-off event, the incident. The child was not in the same room. Okay, this is not the best of situation, but that doesn't justify to break the ties. So what have we done? Said, okay, what about the child? Because he experienced that incident. So we approached the mediator, either at the domicile of the child or in the office of the mediators. Once again, we showed the umbrella. We used the umbrella again, and okay. And I have all the kitchen material in my office for children to play with it, and a toy kitchen, and then the little girl prepares the meal for mommy, and then she first serves her mom and then her father, and then actually the child is fine. He can play with his mom, with his dad, and we are making sure that that incident that has taken place has to be taken into account. So we need to take the into consideration. We have been worried by the child, and we have not denied the fact. Then mediation when the ties are broken down. So even after there has been expertise, that's nothing left, and there is no report with the mediator. There is nothing in writing. And most of the time that applies with teenagers. I tell them that they have to come at least 5 times. We're not talking about mom and dad with whom ties have been broken. So I will just walk them around with my dogs, or I propose to them to go to a climbing gym, and then say, okay, mom or dad, and then, okay, then I will ask the father to secure his child when climbing. So the child or the teenager doesn't have to speak to his father. His father is just there to help him climb, to allow him to climb. So actually, we propose several activities like that, through which we can experience something else than the conflict with parents. And this is all part of what we call standard mediation. And that's it. It's been a pleasure for me to share my practice with you. Thank you, B.
Thank you. So before we're going to have lunch, we have the last speaker, which will be on video. It is Philip Marcus. Philip Marcus is a judge from Israel, and it will take about 20 minutes that he will talking in the video. So after that, we can all go to lunch. But it's really interesting to stay and watch what Philip Marcus has to say. Thank you.
Good day, ladies and gentlemen. It's a great privilege to be taking part in this conference of the Parental Alienation Study Group, particularly since the theme of prevention is one which I have been studying and writing about for the last few years. I've been asked to speak about prevention and early intervention and swift court action, how these work in Israel, what Israel has achieved and what challenges we're facing. And I want to start by speaking about the model of prevention that I've developed together with Nick Child and David Curl, I think yesterday. It's based on 3 elements. The first is primary prevention, which includes raising awareness among the general public of the existence of parental alienation and the other reasons why a child may stop having contact with a parent. It involves raising awareness among those professionals who work with children and their parents on a day-to-day basis, so that they will understand what happens to children whose parents get divorced and what might happen if the parents' separation is not done with the interests of the children in mind. The second stage is to alert people, especially parents and those same professionals, to the first signs of distress in the child which may arise from the parents separating and the level of conflict between the parents, and to bring about immediate intervention with the parents and with the child in order to prevent the situation from deteriorating. The third stage is to make sure that courts, if they are faced with a situation in which one parent alleges that the other is interfering with contact, that these cases are dealt with swiftly and efficiently and effectively. And I'm going to speak about the second and third parts, that is early identification and intervention, and also how court action works in Israel, on the basis of my experience, first as a lawyer and then as a judge, and then since my retirement as a researcher and writer and taking part in programs in these various areas. I want to make it clear that Israel's system is based on social services which are available to the general public, and also a special social services unit which is attached to the courts. I also want to explain that the Israeli judicial system is a common law system based on the adversarial aspect. However, as I've written, elements of what's called therapeutic jurisprudence, or what I prefer to call judicial therapy, are built into the specific family court legislation. One of them is the addition to the court of social workers in the family court social services unit. But there are other aspects in which the court is mandated to act, and does indeed act, in order to take into account not only what the parties want and what they apply for, but also the effect of any process on the parties and those surrounding them, and in the specific cases we're talking about at this conference, their children. The children are not a party to the proceedings unless the court decides that they should be, but they are certainly held very much in mind, both in the processes before the family court social services and when the court comes to determine the issues. We also have a sophisticated system of how the voice of the child is heard, if the child wants to be heard, by the social services of the court. However, after that introduction, I want to go back to the issue of early identification and immediate intervention. I've been working now for the last 4 years or so with an organization in Israel called In Between. The website is called Balev, B-A-L-E-V, and you can look it up. They have a website in English. One of the things we've been doing in this organization In Between, which has a professional consultative board of which I am a member, which includes social workers and psychologists and psychiatrists and educators and lawyers and judges and members of other professions who are involved in one way or another in educating and dealing with children whose parents are separating. We have now for some time been approaching or been approached by members of different professions in order to give direction and training. So, for example, I have lectured before nurses, emergency room nurses, so that they will be able to see when a child is admitted if there is tension between the parents, and if that is affecting the child, how to call in the social services from the hospital. I've been speaking particularly to teachers and to educational counselors in order to explain to them what goes on with a child where the parents are separating and divorced, and if there is violence or abuse or shouting in the family, how that might affect the child, and how to see the signs that a child is affected by what's going on at home. This may take various forms. A child who previously excelled is now deteriorating in his achievements. A child who was previously friendly may become solitary. A child who was previously solitary may now be associating with the less able students. A child may be overeating or may not be eating at all. A child may come in proper clothing in the past and now shows up without proper clothing. A child may not do his homework. There are many other signs which can be picked up, not only by the teacher, but also by the other staff in the school, which indicate that something's going wrong with the child. And we are also helping teachers and parental and educational counselors how to interview the child in a gentle fashion, and then, if necessary, call in the parents and tell them that it appears that disharmony in the family is causing trouble for the child, and recommending that the parents immediately obtain assistance for themselves in order that they should improve their parenting skills and their parenting together, and also help for the child. We're doing the same thing with social workers. I found it very interesting and useful to speak to students of social work and law and education and medicine in order to educate them as to what they might see and how they might be able to intervene. So that is the first part of early identification. Intervention, of course, has to be carried out by people who are skilled and professional and knowledgeable in the field. I'm sure that this conference will include reference to the damage that can be done by an unskilled or unaware therapist, maybe a psychologist, maybe a social worker, who is not aware of the specific features of a child who's affected by parental strife, and therefore there is a necessity to set up a cadre, a group of properly skilled and trained therapeuticians in order to provide the appropriate intervention for the parents and for the child. This involves many issues. One of them is not to be drawn into the conflict between the parents and not to take sides. Another one is to listen to what the child says, but not necessarily take as being the full picture from what the child says, because an alienated child may in fact construct for him or herself a distorted picture of the relationships in the family or of the alienated parent, which, although may sound very convincing, and the child, him or herself, may be convinced that it's true, this may not be necessarily the case because of psychological split or because of the influence of the alienating parent on the child. This is one of the challenges, and that is in Israel, and I think in most countries, to make sure that if a referral is made, it's made to an appropriate person who is knowledgeable and competent and willing to handle these cases, which are in many cases highly charged emotionally. There is another aspect of prevention which actually comes from the court. Although many of my colleagues say that the family court is the last place to go for help when a family is in distress, and I agree with that, nevertheless, there are cases in which the intervention of the court may be essential because there is no other way in which to protect the interests of the child. Israel has a sophisticated system now for arranging for representation of a child by a lawyer who acts as guardian ad litem or as advocate for the child, depending on the age of the child. And this is an important tool in the armory of the judge, because such a lawyer who is experienced may be able to bring the parents to understand much better than their own lawyers what exactly the effects of the proceedings are on the child and what is liable to happen if the case is not resolved immediately. Also, we have developed in Israel a system which requires that where there's an allegation of abuse, including interference in contact between a child and a parent, the case has to be allocated to a judge, and the first hearing in the presence of the parties has to take place within 14 days. This is a directive of the President of the Supreme Court from a few months ago, and in addition, the fact that the case is referred to a specific judge who has full charge of the case in all its aspects leads to continuity of judicial management of the case, which is highly important, as we will see. The case comes before the judge. The parents have to be present. The judge will make an initial investigation of what the allegations are, and if the judge feels that there is prima facie a case that one of the parents is interfering with contact with the other child, between the child and the other parent, even if contact has not yet been broken off completely, the court has a battery of orders that can be made. One is for appointment of an advocate or a guardian ad litem for the child. Another one is referral to a court-appointed expert who will investigate the situation and present a report to the court within 2 or 3 weeks as to whether the allegations of interference with contact have any basis. That expert will be entitled, of course, to see the parents and the child, and the court will add sanctions for non-compliance, so that if one of the parents fails to attend a session with the expert and or fails to bring the child, then it'll be made clear at the very outset that sanctions will be imposed for breach of the order of the court. After getting an initial report, the court can then refer the parents and the child to obtain help in reconciliation, reunification, if that is necessary. And it is very important to emphasize that the orders of the court are useless unless there are sanctions for non-compliance. In Israel, the courts have developed many different ways of imposing sanctions on a recalcitrant parent who is not complying with the orders of the court, including payment of money, including court costs, including a penalty, including a reduction in child maintenance payments, banning the recalcitrant parent from leaving the country, up to and including the imprisonment for contempt of court for a short time. And the orders of the court and the decisions are reported in public, and this is the area in which prevention is effective, because a parent who is considering interfering with contact and sees a report in the newspaper that a parent was fined or sent to prison for failing to comply with orders of the court will think twice about failing to comply with orders about contact. There is, of course, much more to say. As I have told you, the challenges facing the Israeli system are to set up a sufficient number of experts in the field, and of course training of lawyers to recognize the signs of a possibility of a breach of contact. I'll be happy to answer questions, and anyone who is interested in doing so may contact me. My contact details are with the directors of this conference. I want to congratulate Marie-France and her team on setting up this conference. It is a matter of deep regret that because of COVID-19 and for other reasons I'm unable to attend in person, but I do look forward to corresponding with you, speaking to you electronically and meeting you as soon as it's possible. Thank you for your attention.
So thank you everyone for attending this morning. The afternoon will be twice as interesting, but first we are going to have lunchtime. I'll think we'll be back about 1:30 into the room again. Is that okay? Thank you. Enjoy your meal. Thank you for still joining us. I think this afternoon will be very interesting as well. We are going to start with Amy Baker. Amy Baker is a psychologist in the United States. I think she's one of the persons who wrote the most papers about parental alienation. She's also teaching at a university. She has her own practice. She has a lot of experience, and she needed to be here as well. Anyway, or with COVID problems, she's still in the United States. She made a video for us, and we're going to see that right now. So what she's going to tell is about if you see the signs of parental alienation already in a very mild or moderate situation, how you can prevent that it gets worse, how can you reverse the dynamic. So we'll see now Amy Baker.
Topics for this talk: how to enhance the attachment with your child, how to not take the bait, how to invite criticism, how to foster values that can inoculate your child from becoming alienated, and how to teach critical thinking skills. So the first topic is how to enhance the attachment with your child. Alienation works when a parent is able to rupture the attachment by convincing the child that you are unsafe, unloving, and unavailable. So the more you can do to ensure that your child experiences you as safe, loving, and available, the less likely it is that the other parent can turn your child against you. So first, you want to ensure that all your interactions with your child are loving. It's not so much what you do as a parent, but how you do it that creates a feeling that you are safe, loving, and available. For example, if your toddler says to you, "I want ice cream for breakfast," you could say, "That's ridiculous. Who eats ice cream for breakfast?" Or, "Who told you to ask me for ice cream for breakfast? Did your other parent put you up to this?" But if you talk to your child that way, you are conveying you're stupid, or you're wrong, or you're bad. And nobody likes that, right? So why talk to your child in a way that makes them feel badly about themselves? And of course, if you do, they're going to feel badly about you as well. So instead, I recommend saying something like this: "Oh, don't you wish ice cream were a healthy breakfast choice? You can have ice cream after dinner. Now you can choose between pancakes and waffles for breakfast." So joining your child with a wish creates a feeling of closeness. You're not humiliating your child, and at the same time, you are setting an appropriate limit. Another aspect of enhancing the attachment involves taking what I call a blah moment and turning it into an ah moment. You can think of blah moments as non-special moments. You're just sitting there eating breakfast, or you're on the couch watching a movie, and it doesn't feel like anything special in that moment. Later, when the other parent says to the child, oh, you don't really have fun with that parent, you don't really have much of a relationship, it'll be easy for the child to go along with that because the memory trace of that blah moment is sort of a thin memory. It's like a fragile thread that can easily be broken. But if you elevate that moment into an moment, you can think about it like wrapping the thread, strengthening that memory trace. So it will be harder for the other parent to overwrite or erase that memory. So there are three ways to wrap the thread, so to speak, to strengthen that memory. The first is through touch. If you're just hanging out on give them a shoulder. The second is through eye contact. Again, if you're just sitting there having breakfast with your child, make sure to have eye contact, which increases the intensity of a moment. It elevates the moment to feel more special. And the third is through verbalization. You can say to your child, I just love being with you, or I'm so proud of who you are. You're such an awesome kid. You have to mean it. It has to come from your heart. And it really shouldn't be empty praise or lavish and extravagant statements like you're the most wonderful person in the whole world, because that's really not going to be believable to the child. All right, so the second major topic is don't take the bait. Alienated kids often behave very provocatively. They can be uncooperative, negative, contemptuous, surly, and arrogant. They can really push your buttons. But if you respond with anger or depression, normal human reactions when your child is being turned against you, you are inadvertently reinforcing the lie. So the lie is that you're unsafe, unloving, and unavailable. And then if your child behaves in a provocative way, and you respond by screaming at your child or hitting your child or sobbing with despair, the child can rightly say, gee, that other parent is right. This parent is a creep or a monster or a loser. All we do is fight. We don't have fun together. So the first suggestion I want to make when your child is behaving that way just falls under the category of basic cognitive behavioral coping strategies. You want to try not to get flooded with negative feelings. So if you find yourself getting upset with your child, you can always say to your child, we're going to deal with this later. There's absolutely no rule that says that you have to address every discipline or parenting issue in that moment. Second, remember to engage in positive, encouraging self-talk. Try to avoid catastrophizing language like, this is the worst thing that ever happened. I can't handle this. Try to remind yourself that you are strong and capable and resourceful, and you can and will deal with whatever comes your way. 3, take some deep breaths. Okay, taking deep breaths really help calm the nervous system down, and that can help you stay emotionally regulated. And 4th, if you feel that a situation is not going well with your child, remove yourself from the situation. Go to the bathroom, splash some cold water on your face, give yourself a pep talk. You can step away rather than doing or saying something that you would regret. All right, so now I want to offer some suggestions under the category of don't take the bait. Again, let's assume that your child is engaging in a way that's very difficult for you. All right, so my first suggestion is avoid labels. It's never helpful for somebody to refer to somebody else as toxic or abusive or nasty or disrespectful or rude. It's generally demeaning, demoralizing, and humiliating, and it doesn't help foster a feeling of closeness between parent and child. I want to be clear, I'm not saying it's a free-for-all. You're a human being. You have a right to have integrity, to not have somebody treat you in a way that you find unpleasant. If your child is yelling at you or cursing at you or spitting or doing something else that you find very unpleasant, it is most likely because your child is upset. And so I suggest that it's better to start by acknowledging that your child is upset, and by showing that you care, and that's what creates a feeling of connection, and then you address the unpleasant behavior. All right, so here's the 3 steps that I recommend for this situation. I suggest you start by acknowledging that your child is upset. You can say, wow, you're really upset right now, and I can tell, and I really want to understand what's going on. Step 2, you describe in a non-pejorative way what it is your child is doing that you're uncomfortable with without using any labels. So you might say, you're talking in a tone of voice that's very distracting to me. Or you could say, your voice is such a high volume, it's hurting my ears. Or your cursing at me really doesn't feel good for me. What you want to do is provide neutral feedback, such as I don't want to be cursed at, or I don't want to be yelled at. And then you end this strategy, step 3, with an invitation. Can you please tell me what's going on without yelling? Or can you please tell me what's going on without cursing? All right, now let's assume that your child does share a complaint with you, and that complaint is mostly, if not entirely, false, such as you stole my college money, you beat me when I was a baby, you were mean to the other parent. I'm going to teach you now what's called the 5 steps. It doesn't matter what the complaint is. It's for any complaint that's untrue or mostly untrue. So the first thing I'm going to say is, don't say, why would you say that? You know that's not true. Or why would you believe that? That's ridiculous. Or who told you to say that? Who told you about that? All of those statements are unproductive because they're defensive and unkind. And so it's highly unlikely to resolve a conflict with a child if you respond with a defensive version of that's not true. So now I've taken away from you the one thing you're most likely going to want to do, because as a human being, you want to defend yourself if you're being accused of something that's mostly untrue. So now I want to give you the 5 steps, which is what to do instead. Now, I usually spend 20 minutes just going through the 5 steps, so you are going to get a very quick tour. Just know there's a lot more to it, but there just isn't time today. Okay, so the first step is called gratitude. This means telling your child that you are glad that they are sharing the complaint with you. Although you probably do not enjoy your child complaining to you, remember that it's better that the child complains about you to you than the other parent, or shuts down and doesn't speak to you at all. So when your child complains to you, even though you don't enjoy it, you could feel gratitude in your heart that at least your child is talking to you, and at least the child is bringing the complaint to you, because in doing so, they are demonstrating that they're willing to invest energy in the relationship, because when people are done with the relationship, they don't even bother to complain. So that's why you should feel grateful. So when you express gratitude as step 1, you need to do it in 5 sentences of high energy talk. It's not just, gee, thanks, because that's low key energy and too short. So I'm going to give an example of a child named Chris, and you're going to say, Chris, thank you so much for telling me that you think I blah, blah, whatever it is. I cherish our relationship. I hope that I never hurt, frustrate, or disappoint you. But I want you to know that if you feel that I have, I am so grateful that you're letting me know what's on your mind. And you know what? It's easy to complain about somebody behind their back. It takes guts to look me in the eye and tell me what's going on. I'm really proud of you. So step 1 is loaded with positive words: pride, cherish, appreciation, courage, bravery, and gratitude. You want your child to walk away from this experience feeling good about himself. Step 2 is called compassion. This is also 5 sentences of high energy speech. The purpose of compassion is to show your child that you are paying attention to her emotional state in the moment. All right, so you're going to pay attention. And is 5 sentences of high energy speech. I want you to pay attention to your child's words, tone of voice, facial expression, and body posture. And then you will be able to surmise what your child is feeling. And then you will reflect it back in 5 sentences. Like, I can really tell you're angry. Your words are angry, and your tone of voice is very stern and loud. And I can see the anger on your face, the way you're scowling. And I can see the anger in your body, the way you're standing there like a warrior. You are really showing me that you're angry, thinking that I blah, 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 whatever the complaint is. All right, step 3 is called empathy. This is also 5 sentences long, and it's spoken with energy. And the purpose is to show your child that you're trying to look at the situation from your child's point of view. Doesn't matter if you agree or disagree. We're not up to that yet. So to role model it very quickly, you might say, you know, Chris, if I were a 17-year-old girl, so you're plugging in your child's age and gender, and I thought my parent, and then you're going to insert the complaint, beat me when I was a baby or whatever, I would be steaming mad too. I'm really trying to understand our relationship from your point of view. I'm trying to look at things from your perspective. And you know what? If I believe what you believe, I would probably be feeling what you're feeling. I get where you're coming from. All right, now we're going to move to step 4, which is called the minor correction. It's minor because it's short and it's low key. All right, it should be one sentence of your truth. Okay, if the complaint is 100% objectively false, like you stole my college money, you would say, actually, that didn't happen. Just like that, low key. Most of the time, though, the accusation is subjective, so you can't say that didn't happen. So if the complaint is you don't listen, you could say, oh, I thought I was listening. If it's you don't love me, you could say, I know in my heart that I love you. If it's that you yell, I didn't realize you thought I was yelling. And anything to do with the other parent, you can just say, I see that differently, or I have a different memory about that, or I have a different perspective. And step 5 is just a recap of the first 3 steps, all right? So you would just say, that didn't happen, that would be step 4, but I understand you think it did, and that's why you're so upset, and I'm so grateful that you're telling me what's bothering you. So it's just a very quick recap. All right, now, if the accusation is related to the future, like you don't yell, or you don't listen, or you do yell, something that could come up again, you could end step 5 with an invitation saying, you know, would you be willing to tell me the next time you think I'm doing it? Because I'd be happy to, you know, talk in a quieter voice or make more of an effort to listen. All right, now there's something called the modified 5 steps, which is if the accusation is true, like let's say you have a 15-year-old, and let's say when your 15-year-old was 10, you slapped him in the face, you know, and your kid is supposedly still upset about that, right? So you don't want to spend 15 sentences getting through gratitude, compassion, and empathy. You would just very quickly, you know, telescope it to say, you know, thanks so much for telling me you're still upset. I slapped you. I can see it's making you very angry. And I'm really sort of thinking about this from your point of view, and I'm really getting where you're coming from. So you don't need to go into 15 sentences, right? Just a very brief recap of that. And then you acknowledge, you know, I agree. I remember slapping you. And you can apologize. I'm sorry I did that. You can ask questions. Is there anything else that's bothering you? What was it about that? How did that affect you? Show interest in the child's perspective. And then you can end with a wish. If I had a time machine, I would go back in time and I wouldn't have hit you. So there's a couple of final points I want to make about the 5 steps, the modified 5 steps. You know, you might realize, oh man, I missed an opportunity to do it. You can always go back to your kid and say, you know, 10 minutes ago, last year, last week, whatever, and you shared with me you were upset about blah, blah. Boy, I didn't respond the way I wanted to. What I meant to say was, thank you. And then you can just launch into it. The second point I want to make about the 5 steps and the modified 5 steps is if your child says that you sound like a therapist or you sound like you've gotten coaching, you know, instead of feeling guilty, like, ooh, I'm not supposed to do that, I would say embrace it with pride. You're darn tootin', I sound different. I sound like I've been coached. Nothing is more important to me than working on this relationship. I'm consulting all sorts of people so I can be the best parent that I can be. All right, you don't have to feel like it's something to be ashamed of. Topic 3 is inviting criticism. So rather than waiting for your child to be upset and then hoping that your child shares what's on her mind, you can try to identify and diffuse situations and grievances as they arise. And one way to do that is by being proactive. Invite your child to share complaints with you. You know, I don't think a child's going to make up something like, oh, mom asked me to complain. I better come up with a complaint. So it's not like you're going to make anything worse, right? So you don't have to worry that you're like focusing on the negative. So one way to invite criticism that could be fun is you could have a suggestion box in your home. And once a week, you crack it open and you read all the suggestions. You could also just say to your child, like, hey, honey, I hope I never hurt, frustrate, or disappoint you, but if I have or I do, I really hope that you let me know. And then you can say anything you want to share. So if you can get your child to share the grievances as they're happening, then it's less likely that they're going to bring that grievance to the other parent who's going to fan the flames of their discontent. Okay, the next topic I want to talk about is how to foster values in your child. And there are 3 values in particular that are relevant for protecting your child from becoming alienated: forgiveness, compassion, and integrity. So I'm going to explain each one, why it's relevant for alienation, and then talk about what to do. Whoops, I think I lost my forgiveness slide, so sorry about that. So the first value I want to talk about is forgiveness. This is particularly relevant for parental alienation situations because all parents are imperfect. All parents hurt, frustrate, and disappoint their children. So the goal is not for you to be perfect. That would be lovely, but it's obviously not going to happen. The goal is for you to be the best possible parent you can be, and then to have a child who accepts you with your imperfections and is able to forgive you when you do something that bothers them. All right. So what you want to do is foster this value in your child so that your child isn't taught by the other parent, oh, your father served you broccoli. That's unforgivable. Never talk to him again. Right? We want to have your child identify him or herself as somebody who values forgiveness, and then your child will hopefully be able to forgive you. So if your child naturally exhibits forgiveness towards somebody else, then you want to highlight it by using the word forgiveness and commending and praising and appreciating your child. For example, if you have 2 kids, one of your children is very, very annoyed or hurt or angry or frustrated with a sibling, and then forgives that sibling and does something nice for that sibling who had been so annoying earlier, then you can say to your child, wow, your sister was really bugging you earlier, but it looks like you've forgiven her now and you've decided to share your cupcake with her. How does that feel for you? I know I'm impressed. So instead of just saying to your child, well, that's nice, you're sharing, or good girl for sharing your cupcake, you're being very specific about the value that your child is exhibiting and praising and recognizing your child. Certainly, if your child forgives you for something you've done, you can thank your child. So let's say you using the word forgiveness and thereby helping your child develop an identity as somebody who has forgiveness in his or her heart. You can talk out loud as you demonstrate forgiveness through the day. Let's say you're driving in the car with your child and somebody cuts you off, and you can say out loud, boy, that driver really irked me, but I'm going to forgive him because I don't want to carry around anger. It doesn't help me. Or if you're watching a movie or reading a book together with your child, and a character is struggling with the decision about whether to forgive somebody or not, you can ask your child, what do you think that character should do? What would you do if you were in that situation? And if somebody shows forgiveness towards your child, whether it's you or a sibling or a friend, you can say, I was upset with you earlier, but I've decided to forgive you. I'm going to let it go because that will be better for both of us. And then you can ask your child, how does it feel to acknowledge that the world is a better place when people forgive each other? All right, there's my compassion picture. The second relevant value is compassion. This is relevant specifically for parental alienation situations because alienation works when the other parent convinces the child, manipulates the child, tricks the child into believing that your feelings don't matter. And when your child believes that your feelings don't matter, that is a situation in which the child is much more likely to be harsh towards you, to be demeaning or contemptuous, to not factor in your humanity when interacting with you or making decisions. And you don't want your child to break your heart or treat you as if your feelings don't matter. So you want to foster in your child a belief that compassion is an important value. And you want your child to have an identity as someone who has compassion and values it. And the way that you can foster that in your child is the same as forgiveness. Recognize it when it's spontaneous, demonstrate it, talk about characters and real life situations in which compassion is relevant, and certainly praise and appreciate and acknowledge when your child is exhibiting compassion. There's my forgiveness picture, and here's the third value, integrity. And by this, I mean being true to your values, being true to your truth and what you believe, and not being unduly influenced by somebody else to behave in a way that goes against your values. If your child has integrity, it will be harder for the other parent to convince your child that they don't love you, or that you don't love them, or that you're unsafe when you're not unsafe, etc. You want your child to know who you are based on how you relate to the child, not based on what the other parent is telling the child about who you are. So integrity is a very important value to instill in your child. And the way you do that, again, is by acknowledging and recognizing when your child exhibits integrity, such as resisting peer pressure or studying hard when it would be easier to cheat. And there's no obvious reward for studying hard, right? Doing the right thing and recognizing when your child does it, appreciating it, talking out loud as you're dealing with situations, and then again, bringing it up when characters in books and movies are dealing with it. All right, I'm going to wrap up here by saying that I hope this has been helpful. I hope everybody walks away with a few concrete suggestions and ideas about preventing parental alienation. Thank you.
Well, hello. I am Asunción Tejedor, and I'm going to present what we call round table, but we don't have a round table. At least I think we wanted to do it dynamic, and we wanted to present different ways of work we do in Spain. Two lawyers that are going to be here, and 3 psychologists. 2 of them couldn't come, so one presentation will be online, and the other one I will present myself. So I'm going to present my colleagues. In the first place, Ana Pérez Vallejo will explain the ways of the instruments we have with these complete families, and how can they work from the legal system. She's going to speak in Spanish. Sorry, but the presentation will be in English. But I think with her hands, you will feel what she wants or what she means. And then afterwards, Gloria Pérez de Colosea will present also the parental coordination from a lawyer, a practical lawyer. Say they are lawyer, both of them. Ana is a teacher at the University of Almeria, and Gloria comes also from Almeria, and she's a lawyer, a practical, no? You say. And the other 3, we are forensic psychologists. Also, we are mediators and parental coordination, the 3 of us. So a little more simply, but we will talk in different aspects or ways that we can work. Oh, sorry. The different ways we could work in Spain that we did before, because now we have a new law. Probably they will present that is going to change everything. But we will try to explain and present the best we can do. So Anna, please, when you want.
Buenos días a todos. No, este sí. Para el translation. Vale. ¿Sí? Vale. Good afternoon. Más cerca. Madre, qué coñazo. Bueno, disculpen ante todo por tener que hablar, como ha dicho mi compañera, en español. Pero me van a permitir que antes de iniciar la presentación mostrar unas palabras de agradecimiento y también a la misma vez de felicitación a la organización del Congreso, a Marie Lefranc, porque está saliendo perfectamente. Yo creo que a todos nos está sirviendo de mucho y en el fondo, aunque no nos conociéramos, yo particularmente no conocía a ninguno de vosotros, me he sentido plenamente acogida porque creo que en el fondo lo que nos une a todos aquí es precisamente la lucha y la defensa y la protección de los niños y de las niñas que son hijos del divorcio. Bueno, hecho este pequeño inciso, esta pequeña introducción, como ha anunciado Asun, yo voy a hacer un planteamiento, intentaré hablar despacio, un planteamiento sobre un diagnóstico de la situación actual que tenemos en el sistema español, que creo que muchas cosas son trasladables a otros sistemas jurídicos, especialmente de la Europa continental.
There is no translation, but only the PowerPoints will be in English.
Entonces, ¿hablo con esto o con esto? ¿Eh? Vale. Bueno.
Hi. She just said she thanks the organization for this Congress. She said she didn't know you before, but she feels very comfortable among you, this group, and she's very happy to be here. And she specifically thanks Mary Frank to invite her.
Thank you. Bueno, siguiendo ya vamos al grano. Quería partir de unas consideraciones básicas que ya se han dicho aquí, pero que es necesario partir de las mismas, y es que, como ya sabemos, la sentencia de divorcio no pone fin al proceso de familia. Partimos de esa consideración. La situación que se da en los juzgados españoles, en la jurisdicción de familia, es que se ha producido en los 10 últimos años, se han triplicado los procedimientos de modificación de medidas. Y estos procedimientos, más allá de las cifras o de las estadísticas, muestran una realidad, y es que el relitigio y la multiintervención de los tribunales de justicia convierte a los hijos en instrumentos arrojadizos de la situación que les ha tocado vivir. Otra afirmación que podemos hacer, que no cabe ninguna duda, es que el conflicto interparental mal gestionado provoca efectos devastadores en los niños. Y partimos de aquí. Este es nuestro punto de partida. Y es que eso supone un auténtico maltrato o violencia infantil. Partiendo de esta consideración previa, no queda más remedio que por la reciente aprobación en España de una ley orgánica, la Ley Orgánica 8/2021, de 4 de junio, de protección integral a la infancia y a la adolescencia frente a la violencia. Insisto que esta ley, con algunas distorsiones o algunas omisiones o algunas referencias equívocas que hace, sí es verdad que parte de una consideración, y es que la lucha contra la violencia en la infancia es un imperativo de derechos humanos. En el propio preámbulo de la ley se dice que asegurar y promover el respeto de su dignidad humana, integridad física y psicológica mediante la prevención de toda forma de violencia es el punto de arranque también de la ley. Y efectivamente, la prevención, se ha dicho aquí por varios de los ponentes que han intervenido, la prevención es la mejor respuesta a la violencia contra la infancia. Y como ha dicho la Organización Mundial de la Salud, la OMS, la violencia se puede prevenir. Partimos de esta idea también esperanzadora y continuamos con, haciendo una pequeña referencia a esta ley. Esta ley orgánica de protección a la infancia frente a la violencia es una ley que se dice muy ambiciosa, muy amplia y de una repercusión sin precedentes. Y hace o tiene por objeto hacer frente a esa violencia desde un enfoque integral, coordinado, transversal y multidimensional. Abarca, por supuesto, toda la vida del niño y de la niña. Pero por lo que aquí nos interesa hoy resaltar, pone el acento esta ley en el ámbito familiar, también en el escolar como espacio primario de socialización de niños y niñas, pero digo que por lo que aquí nos interesa pone el acento en el ámbito familiar. Es una alerta que hace la ley, porque precisamente en el ámbito familiar es donde se producen todos los incidentes que ocurren en la familia. A pesar de ser la familia el marco legal de seguridad y de desarrollo de niños, niñas y adolescentes. Sí, pero sí estoy leyendo la diapositiva. Vale. Bueno, entonces, en cuanto a la familia, el objetivo prioritario es lo que nos queda, que es el primer escalón de prevención frente a la violencia, y esta ley pone el acento en el ejercicio positivo de la responsabilidad parental y habla de ese concepto como un concepto integrador. También hay que poner de relieve, como hace la ley, esa atención que hay que prestar a la violencia psíquica o emocional propiciada, en este caso, ante divorcios de los que podemos llamar divorcios intratables, en los que se aprecia o puede darse, como estamos viendo, unos niveles muy altos de conflictividad, donde pueden darse también interferencias parentales, donde existe el relitigio y, en muchas ocasiones, la alienación parental, como estamos viendo. Y de otra parte también se pone el acento en lo que son los hijos como víctimas directas de la violencia. Es cierto que la historia de un niño no es ajena a la historia de la pareja. Entonces, la ley, como digo, pone el acento en las medidas preventivas antes que en las medidas terapéuticas. Yo creo que debes dejar que Gloria explique el resto porque no se entera. ¿Pero por qué no se entera? ¿Si lo estás leyendo? Ah, sí. Venga, nada. Bueno, venga, hablamos de... Parece que no se enteran. No, de nada. No. Ah, vale. Y no pueden... Vale. Bueno, pues yo simplemente voy a hacer... Y ahora continúa Gloria. Hablamos de los hijos, un poco de la violencia de género, lo que se llama la violencia vicaria. Y en este caso también quisiera resaltar de la ley, por ser una medida un tanto conflictiva o problemática, que a través de estas leyes recientes se ha establecido la prohibición y la suspensión del régimen de visitas. Se hace en 3 artículos principalmente. En el artículo 544 de la Ley de Enjuiciamiento Criminal, en el artículo 158 del Código Civil y también en el artículo 94 del Código Civil. Se establece de forma muy resumida que no procederá el establecimiento de un régimen de visitas, estancia para los padres cuando se separan en el caso de violencia de género, y si existiera, se suspenderá. Ahora le cedo la palabra a Gloria, que habla en inglés. Vale. ¿Ya? Ya me dice que sigas tú. Venga, sí. Si quieres vosotros, Gloria.
Aquí, ¿no? Ok. Sí. Bueno. Aquí, ¿no? So I'm just trying to okay. Okay. Thanks. And I think that you have not understood, Anna, that it's been mainly talking about the new law we have in Spain now. That is, has got in force a few days ago, and the main change that is going to happen in Spain is that with this law, which is an integral law against violence, and looking forward the children and adolescents, is that whenever there is a violence gender news, the contact with the father or the mother, the absent one, well, the no living one, will be suspended if existing. And if it's not existing yet, it will be just forbidden to have contact with your child just with violence gender the news, just starting. So, and this has all the, I know I cannot, no. Claro, claro. So that's going to make a big change now on, and we don't know what's going to happen because obviously the parental interferences are going to increase. So can we talk about so can we talk about government failure of divorce? Because all the last modifications of laws we have had trying to resolve these problems have any successful. Courts are searching for new formulas to guarantee a peaceful post-breakdown relationship, but we are not really achieving it. So we have different ways to prevent a very conflict divorce once we are in court. We talk about the plan de parentalidad, which is the parenting plan, and it's this. Could we say that this is an extend family convention, or what we call an agreement, family agreement, when we go for a non-defended divorce? But it's not really. The plan de parentalidad, the parenting plan, means the diary, the day-by-day regulation, how the parents are going to manage looking after their kids, and things about the holidays, the education, if they already have this plan made from when they were together, happily living together, or not. That is the moment to take your divorce, your friendly divorce suit law, to the court and say, this is the way we want to divorce, and this is the way we want to look after our children, our child. So it's not just a family agreement, it's a plan of how that family is going to work in the future after the breakdown. And it will be important if this was regulated by law. So not only in friendly divorces, but also in contentious one, defending divorces, proceedings, it should be a requirement to add to the suit law. So I want to get divorced, and this is my parenting plan. So the other part will respond whatever. But at the moment, it is only regulated in the Catalan Civil Code. It is not a national law. Yeah. Okay. Pasa más. Resto lo he dicho. Okay. Just for going faster. If we want to if we want to protect children from what happened in court, because at the moment in Spain, going to court is a litigation issue. It's two parties, one against the other, and it's this concept of winning or losing, which has to stop really, because when talking about family issues, it's not what should happen. So there are two key figures. The proactive there are very few really in Spain, and lawyers, and we should change this concept from the gladiator lawyer to an advocate lawyer, or to a mediator lawyer, to a family lawyer. So we also have the mediation, which is always the core, invite the parties to go to mediation, but it's not mandatory. It's only mandatory for a first like informative session, but nothing else. So usually if the party, if any of the parents don't even attend, there are no consequences at all. Nothing happens. It's not even bad for the proceeding itself. Nothing happens. So, but we have a mediation law that could work, but it's not working very well. And we also have now the parenting coordinator figure starting to be used in Spain. And this is more of a post-divorce proceeding figure. The role of a parental coordinator, it's more in the execution process. It's like an auxiliary figure of the judge, will help the judge with little change of the sentence or the follow-up of the sentence, and helping the parents to go ahead with the post-divorce sentence. It is nothing to do with mediation, but obviously the person, the role of the parenting coordinator has training in mediation and uses tools. We have not yet a legal framework. So there are only a few sentences to talk about the parenting coordinator. Okay, it's not still in the law, and it should be, because it's the way that we have that we can introduce it in the proceeding. We have some articles in the civil code. Okay. We have some articles in the civil code we can attend to, especially one which says that the judge can take all the necessary measures to protect the children, and that is the that is the article we can talk about, and some sentences coming from Catalonia, which is always the pioneers. The functions, and very briefly now, the functions of a parent coordinator are evaluation of the family. It has an educative role, because he has to train, and he has to teach the parents to communicate with each other, not only for the current conflict they are having, but also for the future conflicts that might arise, so they don't have to continuously go to court to resolve. And it can make decisions, very little decisions, just the one the judge has appointed this role for. What happened? We need a legal framework, because the base the basis for this role is only in sentences, but not in the law. We need to define the process, the profile, and the role of the parental coordinator, and exactly what topics he will be able to sort out. And yes, and just about finishes. Sorry, it's not my presentation. It's no, it's just a couple of more things. We have a discussion at the moment: should it be compulsory or voluntary? This figure. If it's voluntary, it will probably happen like it has happened with the mediation. If it's voluntary and nothing happens, if the parties don't want to work with this, we still have only the court to resolve family problems, which is not the best place. So, in my opinion, should be mandatory and should be a judge helper auxiliary figure. It will empty the courts. It will help the families more because it will stop this winning losing concept. But we have to just wait and see. There are a few sentences we can study, but it's still not developed. So, do you want to finish the conclusion? Just read the conclusions, which is a bit what we've been talking about. And sorry for the language. we did our best.
Okay, thank you. I'm sorry. I hope you understood more or less with the presentation. Gloria, la tuya? Yeah, it's okay. Then I think maybe we could see now the presentation from the colleague Noemi, and then afterwards I will finish, and I will be really very quick.
Well, thank you very much to the organization to allow this, to welcome this roundtable and to allow me to participate in it. Sorry, I cannot be present all together with you in this moment, but I'll do my best to participate in this way. Mediation, as an introduction, we are going to situate mediation and parental coordination in the context of the ethic of justice, the ethic of care, and the paradigm of the therapeutic justice. The ethic of justice is centered on maintaining obligation, equity, and fairness through the application of moral principles and rules along the decision-making processes in all levels, whereas the ethic of care approach concentrates on maintaining relationships in terms of involving to protect harmonious ties and responding to the need of others, avoiding violence, damage, and harm, in accordance with the culture of peace and the paradigm of therapeutic justice focus on the role of the law as a therapeutic agent. To find a way of avoiding conflict and promoting Pacific mutual understanding global about ethical decision, there is a need to apply these perspectives integrated and combined, since they do not represent opposite poles, just the contrary. In family law, frequently decisions are problems in family law, frequently decisions are related to highly conflicted dysfunctional situations that are generated as a result of marital separation, which significantly affects children who are part of the family systems, and which has led to the construction of new formulas and methods to address family dynamic at health, social, and legal level. And some countries have already made important changes to their laws in this direction. Mediation, in this direction. Mediation and parenting coordination are two of the few options to protect the rights and the well-being of minors. These processes involve both parents working in collaboration with a neutral third party, trained professionals who normally have a mental health and legal background. Children and teenagers may also be included when it is necessary and when it is appropriate. Mediation in Spain must be voluntary according to their normatives and regulations. Mediation in Spain must be voluntary and confidential. The mediator has no particular power or authority with regards to the legal process, and it is not allowed to report information to the judge. The mediator function would be rather educational, helping parents to better understand the needs of a child, focusing on the dialogue process without involvement into the final agreement of the parents and their parenting plans or issue of dispute. The mediator's main role is to facilitate respectful dialogue and help parents to determine common objectives for their children and how to achieve those objectives as a co-parental responsibility and a positive parentality. Instead, the parental coordination is backed up in Spain on the Article 158 of the Civil Code, and the task of the parental coordination is focused on the need of a specific resource for protection of the children during the process of couple breakdown, and also fulfilling a function of assistance to justice as an instrument based on the paradigm of the therapeutic justice. In fact, it is a TJ instrument promoting the role of the law as a therapeutic agent. It also has another collateral function related to a paradigm shift that aims to promote a social influence and a consequence change of attitude in the field of family crisis associated with the breakup of a couple and the need to protect the emotional ties of children with both parents in a balanced way, avoiding obstacles and interference of one of a parent against the other. Parental coordination is particularly necessary to apply for the sake of protecting family ties in cases when gatekeeping and alienation process are detected, where a reattachment approach is needed. The parental coordinator is normally backed up by the judicial resolution, and its main objective is the protection of minor, but besides facing up the risk implied by the high level of parental conflict, and this model of intervention comes to fill a void and a lack of technical service assistance and collaboration with the legal system in family proceedings. It is a complex, highly collaborative, and implies interdisciplinary methodology, so the work of the parental coordinator requires high qualification and specialized training. Judges still may recommend mediation, psychosocial evaluations, and therapy, but these remedies are often not effective when parents are trapped in chronic conflict or determined to interfere in the relationship with children. So in these cases, a coercive measure is needed to overcome these difficulties. We have to mention particularly the function of parental coordination in cases of gatekeeping and parental alienation process. Parental coordination is particularly necessary to apply as soon as possible for the sake of protecting family ties in those cases when gatekeeping or parental alienation processes are detected. Remarking in these cases the importance of a post-sentence follow-up for monitoring the fulfillment of the protective measures settled by court, including the reattachment process of parent-child relationship to reunify the family. The parental coordination should be normally backed up by the judicial resolution centers in the main objective, the protection of the minors, but besides as prevention to face up the risk implied by the high level of parental conflict detected. And this model of family and legal intervention comes to fill a void and a lack of technical service of assistance in terms of collaboration with the legal system. There are important reasons for introducing this figure, no matter how we can call it. The important thing is the method, and the method that this work provides. Some studies indicate that serious conflicts between parents put children at risk and destroy the benefits that positive parental relationship, harmonious relationships can bring to them. In the most difficult cases, judges often recommend mediation, psychosocial evaluation, or therapy, but these remedies are often not effective when parents are trapped in a chronic conflict and they are not really compelled to overcome these family problems. Families with highly conflicted divorces use these services while at the same time they are initiating numerous legal procedures along the years, which involves a high cost in aspects for society, for the family itself, and mainly for the development of children. This intervention methodology differs from the psychosocial teams, which advise the judge, but basically carrying out an expert evaluation work, and differs from the mediation because it is not compulsory, among other reasons. A coercive measure is definitely needed. Between the difference between mediation and coordination, parental coordination, therefore, the parental coordination differs from family mediation in various senses, but mainly because it does not rely on the will of the parties to reach agreement, and it is in the fact that there is does not exist the confidentiality component, while from the parental coordination, the process, the judge is informed about the evolution and the results that are obtained. And obviously, a parental plan should be elaborated and followed up. Therefore, it is necessary that the professional who assumes parental coordination functions has training and specialized background in legal forensic field, in the expert work with families, and should also be trained in addition to having experience with highly conflicted families, intervention and attachment and reattachment theory therapy approach. We have legal and social aspects, family functioning and dynamics, child and adolescent psychology, domestic violence, psychotherapy and family mediation techniques, and participate in ongoing training activities specialized constantly. The parental coordinator is in charge of re-educating parents about the proper management of conflicts and the decision-making from the co-parenting point of view. This is a psychoeducational task in which they can also provide suggestions and suggest to deal with. The coordinator, the parental coordinator can suggest ideas and sometimes also must take resolutions or decisions. Throughout the entire process, the parental coordinator maintains contact with the judge, with the parties, with the attorneys, and with other professionals who are or have been intervening in these cases. The family courts do not usually have the necessary tools to solve this special problem with the classic means of execution, where a dynamic expert is needed to coordinate the parental functions. And also, it is extremely important to generate law jurisprudence in this direction. Currently, we can affirm that the figure of the parental coordination is being implanted and consolidated progressively in Spain as a clearly delimited professional figure, and there are already different projects that have begun to demonstrate its usefulness to protect minors trapped in highly conflicted ruptures, and mainly to protect the ties and bonds in secure relationships and secure relationships with both parents, producing a change of social and cultural attitude. It's important to add, if I have time enough, that the motivation of the majority of the professionals dedicated to this field of intervention is reinforced by the empirical evidence regarding the urgent needs for this resource and the perception of the void and emptiness that the parental coordination comes to feel in the judicial system. This motivation implies perseverance and dedication to continuous training throughout the entire specialization process during professional practice. Although at this time we still do not have enough studies on its effectiveness, we can already affirm only that there are evidence of benefits in mental health and in saving legal costs achieved by professionals with continuous specific training and experience in this area of knowledge. Thank you very much for your interest.
Okay, well, thank you very much. Now I'm going to wait for my presentation, and I'm sorry, but I think I'm going to explain it quite quick, because I think more or less we are talking about the same. I think in a way we are repeating the same strategies or ways we are working now in Spain. Well, we arrived to this kind of intervention among the years because we had been working with a lot of cases of parental alienation, first call syndrome, then afterwards parental alienation, and now we can't pronounce that in Spain. So I don't know when I go back what I'm going to say, but well, anything I can always describe what is happening. We are really the problem, and I wanted also the lawyers to explain how are we going to deal with this problem. As Jorge wrote in an article, it exists, and we all know, but then we can't just look to another place. We have to go on. And this, why, because it affects not only the children, of course, we always have to say is the main interest of the child, but I think sometimes in the way, many professionals forget that. In many ways, because we can see what is harming, and seeing the film yesterday, we have tears, because it's really sad. And then we have to go on to do our work, but then that problem is still there, and the harm is there, and it continues. And we have to do something. We don't know in which way, but of course, we will try until I get retired. I hope in a way it's not too late. And that is the most important. But of course, normally when they come to ask for help, or maybe in the court with the reports we have to do, it's the parents, the father or the mother who come because we need help. But then we can't forget about the children. They are in many ways deprived to have a normal relationship. I think this is the main subject we are talking here. So we know what is that, and how can we go on. I think the thing is, okay, now I know I diagnosis and this is what is happening. What can I do now? How can repair this situation? And then we work a lot on this situation, but it's not only what we can do, programs, therapy, and many ways. No, we try everything. It is in our hands, but then you suddenly feel that you are not alone. You need the help sometimes from the court, the judge. We need them sometimes to say they go to therapy. But therapy, if I am a clinician, is not compulsory. I mean, it has to be voluntary. They can come because the court said, you go. But then it doesn't mean that they are going to participate. It doesn't mean that I can work with them. Then we have the mediation. Okay, I think it's a good prevention. We are talking, the LEM is prevention, but I don't know in the rest of Europe, but I know in Spain it's not working as it should work, the mediation. Every couple should go to mediation before they decide to break their relationship. But it's not always like that. I work in the court with, in the mediation, but the cases that come to our office, they are always very high conflict, and the mediation is voluntary. So if they don't want to participate, if they just want to stand up and nothing else, we can't do anything. And then we still have the problems, no? And that is the question, that we don't resolve the matter and it goes to different professionals, and then the cases go back to the court again. Because they said, well, we had a problem, we went to therapy, to mediation, to everything, but then we are back again, asking for, I don't know how to say in English, that execution of the sentence, you know? They said, if the sentence said that I have to pick up my children at 2 o'clock and I have to be the weekend, I can go. No? But it doesn't happen. And it's, the problem, I think, is, I only talk for what I know in Spain, is it has no consequences. That if the father or the mother goes to pick up the children and they are not there, or they are not, well, they can't go with the father or the mother, has no consequences. He just, or she just has to go and nothing happens. And then has to go to court to say, well, you said this is what has to be like that, and it didn't. Sometimes to the judge I said, well, you have the power, why don't you use your hammer, no? And please tell these people or tell something. But even with penalties like maybe 600 or 1,000 euros of penalty, nothing happens, because they say, okay, I pay in small amount, 100 euros a month, but my children stay with me and not with the father or the mother. So that is not a solution, evidently. And also because the children will suffer for that situation. So we come with this, now we are reporting that these are highly or high conflict families, because they are in a circle and they move around, they go to, they visit many professionals, apart from lawyers and, well, many different professionals. Sometimes they try to choose the one who is going to say what I want, and sometimes they maybe talk with another professional that said, no, what you are doing is not right. And then what can I do if I see that case? So I go to the court and say, this is maltreatment, it's difficult the word, maltreatment to the children, what this person is doing. Normally, in other conditions, if sexual abuse or another kind of maltreatment, we are obliged to go to court and to report. But if we have in the consultation these cases, normally we can see and say, I know what you are doing, I can write a report, but I can't not denounce this. And so sometimes maybe I feel brave and I would like to do more things that I can, no? so I have to go back in many occasions. But I go on with trying to find the way to resolve these problems. We are always looking for solutions. Programs, of course, we found programs that we tried, not only because with two forensics in Catalonia, me, we wrote a program with special treatment for these interference cases or parental alienation cases. But always you find that you need the cooperation. If one of them doesn't cooperate, I mean, you can work with the children, you can work with the father or mother, but if you don't work with the other part, nothing what you do is, I mean, you say something and they go back home, and so it starts again. So we found that we need the help of the court. And for that, I think it all goes, you know, one after the other. We found out, even if it was many years ago working in other countries at the United States and Canada, now in Spain, we found out about the parental coordination that is Noemi mentioned, and also I'm going to talk a little about it. The parental coordination, for me, the difference was not because, I mean, I don't have the power as the judge, no? But in a way, I have a small power, is that I have a contact, direct contact with the court, because they said to me, I want this family to work and I want these children function with the father or the mother. And then if it doesn't work, I want to know, and I can take another measures or another results, you know. So I think for us, it's a different work, a different way to work. It's not like you are a clinician. Now I can tell them, well, look, I want to help you, and I really, if you don't participate, if you don't cooperate, or if you try to boycott what I'm going to suggest, then we will go to the court. I mean, they are not afraid of going to the court, because you find families that they had been in the court very often and nothing happened. I mean, they are not afraid. Normally, when I go to the court, I have a little here, you know, because you have to talk maybe in the court for the report and like that. They have no problem. Well, I think this figure, as they mentioned, the parenting coordinator, is very important. And we are trying very hard to do the implementation in Spain. Now I'm going to talk about the implementation. That is my friend Nuria, who couldn't come here, and she's going to present how it works. Even if we can't mention the parental alienation or interferences or anything, at least I think we have many just that they know, they really know, because they see every day what is happening with these families. And I think, you know, sometimes the politics and the law go in one way and the professionals go in another way. I mean, it could be better if we could go together. But anyway, we are working, because I don't think all of us, we can just go and walk in another direction. It is impossible. We want to do it. And then we have some difficulties, of course, for to get these chances to work with these families. First, because sometimes it's a question of years. I mean, it's not because they had the problem last month. No, we are talking some families that they had been maybe 6 and more, 6, 10, or maybe more years fighting. And so, as we say, the psychologists, there is something inside. When we say that the memory can be changed, it's true. I mean, it's a strategy. It's a way to change. I think they're going to tell me that I have only 10 minutes. Oh, 5. Okay, then I think if you can put the other presentation, the Nuria, then I finish with the implementation of the parenting coordination. And I start talking now what Nuria is presenting, but with my voice. I'm going to resume because I know we have no time. But it's more or less the same. I mean, we go in the same direction and working hard. We had been teaching not only at the university, because now we have expert courses in the expert courses at the university, forming the professionals to be parental coordinators. Not only are psychologists, they can be lawyers, social workers, everything, you know. Well, they need to have a background studies to be or to become a parental coordination. But this started in Catalonia, this part of Spain, where a magistrate, Pascual Ortuño, with a case of the many he had, with problems, he said, I have to do something. It's because it's heavy, you know? Yeah. A parental, they said, well, this case is really hard and I need something. And he heard about the parenting coordination, and then he decided to get more information and try with the professionals to solve the problem this family had. So that was the first occasion, and after that, we had many cases. That all the cases we did high conflictive cases went to a parent continuation, and that changed the way in some places. They work with these families. Still 2 or 3 minutes, because I don't have the presentation. 2 minutes. Eh? And then, well, it was the way to start. And after that, it all is in that area of the Mediterranean part of Spain. In Castellón also, they started a program paid, but the local court. What is good, because it was free for the person who had to go there. And what I remember, because I don't have the presentation, but I think in 2 or 3 years, they had 139 cases to work. And of that 139, I think 57 in those years finished with success. It means that they work for 1 or 2 years, the time they need to help that family to change their attitude, sometimes not only with one, but with the other too, because one can come, let's say, and I am a victim too, but sometimes, well, the victims are the children, but we have to work with both of them, with one because their attitude maybe is to interfere, and the other one because doesn't know how to respond, how to change also the way to communicate with the other part. I think that success of 57, I think, is fantastic. So it meant that in many universities in that area started giving formation to the professionals. I started also in Madrid in one university, and in Madrid now is working through another association. Well, we tried that to be free, but in other occasions it's not free. I mean, the people have to pay, but I think it's for the well-being of the children, and it's not that expensive, no? Because after 7, 10 years sometimes, I think it's worth it to pay for it. So the Minister of Justice in Spain also said and sent, I think, a mention to all the court that that figure, the parenting coordination, should be implemented in all the courts of course, we are still waiting, at least in the area I live in North Spain. We have people formed, but we have a list, but we are waiting. They said they have no money. But I think where it's working, the results are very good. I mean, it has many advantages for the court with less cases. Because we always say that one case after the other can start with all the high conflict. With this parent coordination, cases go down. Family don't go back to the court to resolve the problems because they learn how to solve future problems for themselves. And of course, the best is the children, that they gain the father and the mother in the special conditions that any of them can have. Sometimes can have really a serious problem, like alcoholism, drugs, anything. But through the parenting coordination, we help these people to resolve that problem and to be able to stay with the children. So the children will have the family. Probably they don't forget completely what they have lived, but the future is what we can change, not the past. Well, thank you very much. I'm sorry for the time, but many things kept here for next year. Thank you.
Thank you. Okay, so thank you for this presentation and interesting things happening in Spain. Our next speaker is Simona Vladica. Simona Vladica is from Romania, and I will give the speech to her.
Thank you very much, Oliver. Thank you very much, the whole organizers, for inviting me here. Thank you, Marie-France. Thank you, Jorge. So I came here from Romania with some colors because we are talking about kids. So when we are talking about kids, we have to be happy. So I started to be involved in this field around 2014. Since then, I'm working especially with judges, prosecutors, future judges, future prosecutors, and with mediators and less with lawyers. First of all, allow me to introduce myself. So my name is Simona Vladica. I have a PhD in psychology. I'm teaching at the university. And I'm a mediator too. So today I'm going to share with you the experience, my experience, our experience regarding to parental alienation in Romania. Just see how it works. Okay. As you know, children are like wet cement. Whatever falls on them makes an impression. And, you know, the alienated parent, the victim, as I could see, studying a lot of files, often does not understand that it is not the child's fault because he or she rejected him or her. In fact, the child has no choice to do that. I'm telling you this because this situation caused a lot of problems regarding to alienated parent behavior. So we are in the vicious circle. Actually, parents who practice alienation love their children conditionally. Or I'm still wondering if all the parents love their kids. And I think the answer is no. I think that all the children love their parents, but not all the parents love their children. So this is my personal conclusion. So this is an image who can describe the best way the situation. Parental alienation destroys both the child and his parents one by one. When the emotional traumas of one of the parents cannot be managed properly by themselves, or when material aspects are more important than the child's well-being state, or revenge is more important, or maybe when a mother-in-law is involved, because in Romania we have a lot of kindly mothers-in-law involved in this conflict, or even when the new a parent's partner has an opinion and he is not agree with, I don't know, what kind of visiting program, a conflict appears between parents, and as a consequence, the child becomes a victim for sure very soon. So I'm talking about a little bit about Romanian situation and about the measures taken by some judges and some prosecutors, because they started to hear about parental alienation, as I told you before, around 2014, when I organized in a partnership with Bucharest Tribunal the first conference about parental alienation. And after that, judges told me, you know, after that conference, I went home and I started to search using the internet about parental alienation. So since then, we've organized many conferences in Romania. The last one was in Jorge, help me, 2019. Jorge was there with us, and I'm very grateful for this. Thank you. So in the room were just judges and prosecutors, because, you know, in a way, it's a little bit impossible to put in the same room in Romania. Judges, prosecutors, and lawyers, because if a judge says something, a lawyer goes to the court, in front of the court, the next few weeks, I don't know when, and some of them told, you know, you told us to that conference that. So for these reasons, they try to avoid to have a public speaking, let's say, in front of the lawyers. So we decided then to be just professionals, means psychologists, judges, and prosecutors. So I would like to have a look to that yellow file. Actually, it's a file, not files. It's just one case there. Just one case. So it looks like in Romanian courts. So a lot of papers, a lot of expertises, a lot of evidence there, a lot of works. So this is how they look like. It takes time to solve this kind of files. So I think we don't need necessary law, because we have law. But we need to understand the gravity of this phenomenon and try to think together what we can do to stop the spreading all over the world and also in Romania. We also have in Romania, in the civil code, joint parental authority. I don't know, I'm still asking if it's good or not in Romania, because this situation generates a lot of conflicts between parents, because I want to that school, no, I want to the other school. So the conflict starts. But thanks to a lot of workshops, a lot of conferences, as I told you before, judges, starting, not all of them, we still have problem in this field, started to ask for the psychological expertise of the child, and I'm trying to convince them to ask for both parents, because just child, to expertise the child, it's not enough. So they started to understand that it's very useful for them to ask for the psychological expertise to identify emotional abuse. Some of them still telling me they don't need any help. They just hearing the minor and they know what to do. But some of them recognize our job like psychologists, and they are grateful that we can help them. They listen to the minor and notice everything or almost everything in a hearing report. As I spoke with a judge, it's a problem also here because sometimes the other parent go quickly to the file, ask for a copy to the hearing report and go home and punish the child because he said that and that and that. And we had a very not nice case when the child was punished, arrived to the hospital, in fact. So we have to be careful what judges write there. They have to be careful. Some of them started to extend the program of personal ties to the limit of physical custody. We started to have judicial practice in this field. So these things, it's encouraging, let's say. They sent to the psychological counseling, but as I told you before, not all of them. Some of prosecutors, for example, just didn't understand our profession, like psychologists. They told me, what should you tell me in this expertise report? And slowly, step by step, we are trying to explain them how useful it is to have a team. More important is that the judges attend classes, workshops about parental alienation. This is very, very important. And the National Institute of Magistracy, who are training the future judges and prosecutors, started to have, time to time, some conferences with the future judges and prosecutors about parental alienation. They are starting to be speakers at the conference. They came with their decisions, and I'm very happy with this. They started to write in their court decisions that the alienating parent has the obligation to drive the minor to the other parent's home. Because, you know, nowadays in Romania, the other parent come to pick up the child, and the other parent sitting behind the door and push the child, come, go, but it's a fake because the children was trained before to not go. So one step forward is to ask to that parent to take the children in his or her car or by train or by, doesn't matter what, to go by himself to the other parent's home. So I'm very happy because 1 month ago I read a court decision regarding to this aspect. So one judge ordered this, and I'm very grateful for this. They started to write in the court decisions that the visiting program must take place without the presence of the alienator, because as you know, the alienating parent asks every time to be there to see everything what happened. As a team, they working together with psychologists, mediators, prosecutors for amending legislation. And as Jorge knows already, we have a teamwork group at the Bucharest Tribunal, who is the biggest in Romania, the biggest court in Romania. We are trying to amending legislation using all the information we have. So prosecutors starting to ask for being investigating for the crime of non-compliance with the decisions of custody of the minor. So they ask for alienators to be sentenced to prison. So I have some cases who were solved just in penal law. So a mother who didn't see her children for 5 years, suddenly when the case went in front of the penal court, suddenly when she opened the door, the two boys were there because the father was afraid to go to prison. But not all of them are afraid of prison. Some of them are ready to go in prison. Yes, it's just amazing. So we are starting to have judicial practice also in the penal law. They started to punish to jail, even by postponing punishment under supervision for 2 years. Okay, we have also a problem, like in Spain, there is no penalty if they do not respect the court decision, means in civil code, but just in penal code when they can go to prison for that. They order a criminal fine for abuser. We have in Romania more steps, and the final step is if the abuser do not respect anything, they have to pay a fine per day of delay. So they are asked to go with the children to the other parent's home, and if they still refuse, they have to pay a fine like 50 euros per day, up to they decided to respect the law. So amending legislation in Romania, we have a problem with an article in the law, refusal of the minor, and if the minor refuses to go, we are in a bad situation. Actually, the whole process is for nothing because the justice can be done. So rectification of that article of the law, where we have the obligation of the minor to attend to psychological counseling for 3 months. In fact, both parents and the minor must have the obligation to be there at psychological counseling sessions, not just the child, because it's nothing to be just the child, because the child come back home and nothing happened. Establishing penalty for those parents who do not show up for psychological counseling sessions or do not cooperate in the sense of being actively involved in the psychological counseling sessions of all those involved in the conflict. Because some of them, they are going just in front of the door of psychologist and they refuses to enter in the room. Actually, the child refuses, you know, and nothing can be done. So we need a penalty. Okay, establishment, what we propose, like concrete measures, establishment of a group of forensic psychologists in addition to the courts. Actually, we have to include the specialty of psychology in the nomenclature of specializations of judicial technical expertise. Okay, parental alienation was found to be, as I told you before, a criminal offense present in the situation of this article. Therefore, the offense under this article protects the natural continuation of the non-resident parent-child relationship against possible abuses of the resident parent. So this is the article. I hope that everybody will receive the PowerPoint. So if you need more information, you can find it all here. One thing's important to know, the parent must request the program of personal ties as extensive as possible, because in Romania, if you don't ask, you don't get it. Simple. We have also a problem in law with notarial convention of divorce, because it's not a court decision. So the incidents of the article in penal law, they are not applied. So this is how new abuses are born. Okay. So nowadays, as I told you before, we have a working group. We are planning to propose the best legislative solutions to prevent and stop the spreading of the phenomenon. Legislation still has gaps in this sensitive field. And as you know, we have to do something with the time because parental alienation takes time, and unfortunately, judicial system gives us the time, gives us the alienators the time. So here you will find, if you want to read this PowerPoint, a lot of situations from court decisions. So here you have some examples. So some study cases. I do not have time to present it here, but if you are interested in, you can have it, you can read it, you can use it like a judicial practice, and so on. So some photos from our courses. And thank you very much for being here. And congratulations one more time, Marie-France, for this event. Congratulations, Olivier. I'm very impressed about the presence of the Ministry of Justice yesterday about his magnificent speech. So all the Romania knows already about this. I posted on Facebook, and I sent a message to that group, and I said, okay, let's go on. Things are moving. Thank you very much.
Thank you very much, Simona. Our next speaker, before the pause, we will take a break within 20 minutes. Our next speaker is Brian O'Sullivan. Brian is from Ireland. He's actually a systemic family therapist. He also is a court or expert witness for courts. And he has a lot of experience, and he's going to talk about solutions and the best practice he has in Ireland. Welcome.
Thank you very much, Olivier. So I'm speaking just before the coffee. No pressure on Brian then. I promise I'll keep it as tight to the time as I can. So good afternoon, everybody. Olivier, and I'd like to say a big thank you to Olivier and Marie and the Executive Committee in inviting me to be with you here today to share with you some of the ideas in relation to the work that I've been doing in Ireland. There's two pieces. The first piece I'd like to do is invite you to view a video. It's 8 minutes long, and then you'll only have to listen to me speak for about 12 minutes. I think that brings me, if my maths are correct, that brings me to about 20 minutes. Okay, in terms of the video, guys, this is a lived experience of an alienated mother in Ireland. Sheila, not her real name, was and is a normal range, healthy parent. She encouraged her daughter to have regular contact with the other parent for two reasons. One, she knew it was important that her daughter would have contact with the other parent. And the second reason was she enjoyed the break. So when her daughter was on parenting time with her dad, it meant that Sheila was able to socialize with friends and so on and so forth in a normal range, healthy way. One Sunday, I think it was a Sunday, one weekend, Dad simply did not return this 8-year-old child to Mum. And that was in 2008. That child is 22 today, and Mum has been effectively erased out of the life of that child. So this is her story. I'd like to invite you to spend a few moments just to view it. Bear with me a moment. I hope the link will work. Oh, actually, sorry guys. Before we start, let me just be a little bit clear around what I'm about here today. As I mentioned, or as Olivier mentioned, I'm a systemic family psychotherapist. What does that mean? It means I spent 7 years undergoing clinical and academic training to be accredited as such. In Ireland, I've conducted the only published study on parental alienation. I utilised IPA, interpretative phenomenological analysis. I still get tongue twisted saying that. There is another piece of research was conducted by an MSc student recently. I'm hoping she publishes it. I know there is a PhD student in University College Cork, and I'm really looking forward to reading the results of his research in relation to parental alienation. And of course, there's another practitioner in Arklow who would have conducted a thesis on parental alienation. There you are. I'm the co-founder of parentalalienation.eu. It's a platform designed as a support and resource for professionals who find themselves navigating this space. I'm often asked to act as an expert witness in Northern Ireland and Southern Ireland. Most of you probably know that Northern Ireland is the UK. And it's very often in complex private family law proceedings where parental alienation is considered to be a factor. I have designed and developed the first accredited professional training in Ireland, addressing the theme of parental alienation. But I'm also really excited to have been involved in the development of what I believe to be the first accredited European postgraduate certificate in parental alienation studies, validated by the Maltese Institute of Higher and Further Education, and that was in collaboration with the Institute of Family Therapy and Systemic Practice in Malta. That's commencing in October, so we're really excited about that. Okay, let's scoot along.
And I was in court for about 5 years. So my experience of being an alienated mother is quite horrific, really, because you have your baby, you rear your child, and the last thing you expect is somebody to come and take your child from you for no reason at all. Then they make these orders. The judge will say, well, we need a Section 47 report. And that's where they get an independent person to come out and evaluate you as a parent and evaluate your home and your family. And then they go back in and the other side mightn't be happy with the result of the report. And they contest that and they get another report. Now, in my case, the professional who dealt with my daughter wasn't an accredited therapist. He wasn't qualified to even speak with my daughter. And he didn't have my consent, so I didn't even know that my daughter was being interviewed by this person. He didn't know the colour of my eyes. He didn't know anything about me. And he was able to write 3 pages of absolute rubbish about a person he never met. And on his recommendations, that's why the judge made his decision. So we got the Section 47 done, and they established that I didn't do anything wrong to my child and that she should come back to me. But it took, I'd say, 10, 11 months before that was in front of a court. And by that time, I hadn't seen my child in that length of time. And all you're being told is your child doesn't want to see you. And then there's more Section 47s. I've had 5 Section 47s done. For somebody to say you're not capable of looking after this human being that you brought into the world and you nursed and got them to school and got them over their first illness, all of that, to be told you're no longer any use anymore. I had to give up my work because I couldn't cope. I didn't have a grave to go to. I had a child out there, but I wasn't the mother anymore. And people looking at you and thinking that you did something. And people that know you know that you didn't do anything. In your home, then, you go into her bedroom. And I found myself going into her bedroom many days and lying on her bed and crying. And the only consolation was I could smell her hair off her pillow. She had a Barney pillow. And even though she thought she was a big girl and she had, like I say, all girly stuff like pink things all over the place, she still kept her baby pillow. And as a mother, when you're nursing them and you're feeding them, you're smelling their head and you know their smell. But when your child is gone, eventually that smell goes off the pillow and then you can't smell her anymore and there's nothing there. She probably doesn't even remember. This is her first little rattler and it was just made up of a few stones and a few things. But that's her little rattler. Yeah, this was her first book that I bought her. And again, that wasn't taken with her. Everything was just left behind. Everything is left. Nothing was taken. All her clothes, everything, her dolls, the dolls that she used to want me to move around the house and mind while she was at school, and she had them named, and everything was left. Everything that was important to her was just gone. She didn't bring any of it with her. We used to go to the woods, actually I haven't seen this now for a while, but we used to go to the woods and she'd collect leaves and she'd dry them out and she'd make paper little weights with them and she'd wrap them around. There's her little baby bracelet and her little garden angel chain, everything. And like, these people don't know. They're making orders and they're saying things about people and they're destroying lives. They're just destroying lives.
She rang me and she said goodbye on the phone. She's actually taken a cocktail of drugs. She's not living, she's existing. Then you'd hear people saying, oh, something must have happened, you know. Something must have happened for a child to be taken from their mother. But it didn't. It was circumstances. She was just unlucky. Wrong place, wrong time.
When this happened to me, I didn't know any other mother. I didn't know what this was. I travelled to the UK to a doctor over there and he educated me on what was actually happening. I couldn't believe that my daughter was saying the things that she was saying. She'd say, oh, I'm in fear of my life. I'm afraid to be near her. She's bad, she's evil. And she couldn't have meant those things that she said. She'd make these little things. She made this in, actually, so this is the 5th of the 2nd, 2008. And you can see there she's written the date on it. And that was in 2008, and that's when she left. She went in March 2008. So we've been out in the woods collecting stuff and doing all of these things, and next thing, she's gone. We always went to the park or to the woods or to the beach. And now I do have to bring my nieces to the park. I don't get on to the girls that I'm sad, but I do get very, very low when I'm in the park looking at them, having fun, and there's one person missing. And it's the same at Christmas. There's always one chair that's empty because of what they've done.
I do believe that this was given to her because she has the strength, and genuinely I believe that this is happening for a reason, that she's going to change and make people aware of parental alienation, so to help more people that this won't happen again.
Okay, so I suppose for me, one of the key pieces that resonate with me is the fact that there was several alleged experts who were on that case. And there was at least one in particular who actually felt it was okay to write a report submitted to the court and never having actually met the parent. It's absolutely incredible. However, let's scoot along. Okay. So, I suppose I started doing some work in terms of reconnecting young people with alienated parents in late 2019. That was the first time a case was referred to me. And just some baseline, I suppose, basic information there. It involved two young people, 6 and 8 years of age. They had no contact with their normal range healthy parent for the past 11 months at that point in time. The court, to my knowledge, and it's only my knowledge, I mean, things may have happened I wouldn't be aware of, but to my knowledge, that was the first time in Ireland that a court ordered interim residency transfer of children from an alienating parent to an alienated parent. Okay. Okay, so there are some prerequisites that I insist on before I will do any work with families in this space. The first prerequisite is that the court must make an order transferring residency of the child on an interim basis from the alienating parent to the alienated parent for a period of 3 months. Now, the idea behind that is that it provides optimal opportunities for the young people or children to reconcile and rebuild their relationship with their normal range, healthy but alienated parent. Now, some people will say things to me like, that sounds kind of radical. And I'm often reminded of Mandy Matheson's remarks in one of her books recently, where she points out very, very clearly there is absolutely nothing in the literature that says returning a child to a normal range healthy parent is harmful to that child. Okay. There's also will have to be a no contact order between the young people and children and the alienating parent for 3 months. If a parent disregards that no contact order, the clock restarts again. So if a parent disregards it 10 days in, the 90-day clock restarts again 10 days in. Let me just be really clear here. The cases I'm working with will have been in the courts for many years, anywhere between 2, 5, 6, 8 years in courts before they come to me. There will have been a no contact between the young people and a normal range healthy parent for anywhere between 2+ years. These families will have been to mediation. They will have been to therapeutic processes in the past. And they're still in a high conflict context many years later. Okay. Of course, and absolutely, of course, then what's required is that the family are referred into what I call a parallel process, whereby the young people, the alienating parent, and the alienated parent, over the course of the 3 months, navigate and action several tasks. The primary aim of this model is to ensure that the young people and the children navigate back to a relationship with both of their parents. In Ireland, every time a judge has ordered interim residency transfer, interim, I'm deliberately emphasizing that, it has successfully reconnected every child of each of those families with the previously alienated parent. Each of those children and young people today have a relationship with both of their parents. Okay. So some other aims of the model are to improve the quality of the parent-child relationship with the alienated parents, but also with the alienated parent's extended family. You will all know very, very well that oftentimes parents, or excuse me, grandparents and aunts and uncles and so on and so forth are often inexplicably reject it. Okay. Other aims include the ideas around promoting healthy child adjustment, help the child to understand how and why the alienation occurred, and help the alienating parent understand how and why the alienation occurred. Some other ideas in terms of aims include that idea of working with each family member to create more appropriate parent-to-parent and parent-to-child roles, responsibilities and boundaries. And then there's the idea of promoting relationships between the child or children and both parents, as I've mentioned. There's essentially two parts to this model. The first part relates to the interim residency transfer in severe cases of parental alienation to the alienated parent, and then that family engages in a parallel process over the 3-month period. And as I've said, the aim is for the child to navigate back to both parents. Part 2 relates to the post 3-month period, where the children, once the alienating parent has actioned several tasks during the process, when we come to part 2 of this model, we can very, very quickly move into a parallel parenting arrangement where this young person has regular, ongoing, routine contact with both parents. Okay, so the children will often, young people will often engage for typically 10 consultations. The alienated parents, typically 12 to 15 consultations, and the alienating parents, typically 20 to 30 consultations. In terms of working with the children, some of the ideas I have in relation to that are developing the children's critical thinking skills, so they develop a more balanced and nuanced view of both parents. Another idea is enabling and empowering the young people and the children with strategies so that they can detriangulate from the parental conflict. Another focus includes that idea of developing the young people and children's problem-solving skills, developing their communication skills, and replacing the children in an appropriate social hierarchical position within the family. Because as we know, very often they become over-empowered. And then, of course, with the young people, there'll be ideas around resolving the themes of loss, anger, and self-blame. With the alienated parent, it's about conflict management, communication skills, developing a tangible parallel parenting arrangement. Over the course of the 3 months, psychoeducation in relation to those ideas around circular causality and alienating dynamics. Also, both parents will develop and agree with me an agreed narrative that will be delivered to the child going forward. That will address very clearly the past conflict and so on and so forth within the family. Okay. Again, with the alienating parent, it's a parallel process. They never meet over the 3-month period. But again, it's about, there's that idea of developing that parent's capacity for insight, awareness, and reflexivity regarding their contribution to the alienating dynamic. Like I've mentioned with the other parent, there's that idea of them developing a tangible, child-centered parallel parenting arrangement to be implemented post 3 months. Conflict and anger management, communication skills, parenting skills, psychoeducation, I've mentioned already, and that idea of developing an agreed narrative that is delivered to the young people or children at the end of the process. The results, as I've mentioned, every single case that's been referred to me where there was an order for interim residency transfer, and each of those cases were severe cases of alienation where there had been no contact between children and young people for an extended period of time. Those children today have a relationship with both of their parents. Now, let me just, before I finish up, I'm mindful of the coffee. Before we finish up, I'd just like to bring your attention again to that idea of what I believe to be the first academically validated postgraduate certificate in parental alienation studies, commencing October 21. The aim there is to try and bring some sense of collaboration, cohesion in terms of the assessments, the interventions, and so on and so forth in this space. So there's a link if you're interested. After that, guys, thank you for your ears and enjoy your coffee.
Thank you, Brian. Just before we go into break, I want to bring a message, because when you saw the film of Jan James, you saw the father who was testimonying about the child who was murdered. Okay, so actually, Brian, you had contact with Jan, and she had to say something about it. Can you explain us?
Thanks for that, Olivia. Just to say, guys, I noticed that yesterday there were some questions around the outcome for the mother that in the video that Jan had shared earlier. So Jan has kindly reached out to me and has made it very clear that that mother received an 18-year jail sentence for the murder of that child.
So she was sentenced to jail for that crime. Okay. Okay. So we're going to have a 15-minute break. And after the break, it will be very interesting. We're going to do some questions with and then afterwards we will do the conclusions of this conference. Okay, so I hope to see you in 15 minutes back here. All right, thank you.
Okay, let's start. Okay, welcome for this last part of the conference. We will now have a debate on the necessary legislative changes in the short term, and to this end we have 5 panelists. Ursula, whom you are familiar with, Marie-France Carlier, the judge, you know her, Mr. Bernard de Vos, who is the General Delegate to the Children's Rights for Wallonia and Brussels, and Mr. Raphaël Noiset, who is advisor to the Minister in charge of Youth, and Mr. Zamito, who is an advisor to the Minister of Justice. So, Marie-France, the floor is yours. You can talk about the necessary legislative measures. The question, is there a need or not for changes in the legislative framework in order to prevent the disruption of the ties? Is it just a matter of changing attitudes and minds, or do you think that some legislative changes could be changes? Okay, Mr. De Vos, I will give you the floor because many parents write to you, I suppose. Yes, thank you. Thank you for this question, which is a rather complex one. Working at the community level in Belgium, other decisions can be taken at federal level, but at the community level, some changes were made lately in a decree that changed the youth code in Wallonia. And what is new is that the word prevention is coined in the decree. In the past, the focus was not so much on prevention. Now, the idea is really to try and provide support to the families at early stages. And on a personal note, I'm strongly convinced of the need of a dual measure, dual mandate, although it's difficult to put in place. I have brought up this idea a long time ago. I thought of that for young people who were sent to closed shelters. I thought that we could not put a young offender in the fridge, so to speak, and expect this young person to get back to his or her family after some time. So 12 years ago, at the beginning of my first mandate, I suggested that a double measure be taken for the young, i.e. the young is sent to an open or closed shelter, and then a team of specialists, of experts, will provide support to families to work on parental skills and to try and sort out all kinds of problems that are regularly met in those cases. So I thought it would be good to have the same dual approach for all placement situation. So I'm not in favor or against placement. My background is I was trained as an educator, and I always try to act in the interest of the family, of the child, of the society. So in my view, there is need of a holistic approach to protect the society, the family, and sometimes children have to be taken out of their family environment. But unlike a couple of years ago, we are no longer the world champions in the number of placements, but in Europe we are still the European champions of the length of placement, and so the family disruptions can further worsen with time. So to be brief, to put in a nutshell, I think that on the one hand you have a placement of a young people, of a young girl or boy, who will then enjoy the support of a multidisciplinary team, and at the same time this educational team will go and meet parents on a regular basis. So this means a real mandate with a real workload. So the educational team will not go and meet the parents just to have a chat around a cup of coffee or a cup of tea, but really to have a genuine interaction with the parents, to look at the behaviors, at the attitudes, at the things that need to be changed. So all this is in line with the International Convention on the Rights of Child, which says that the first and main environment for any child is his or her family, and also to take into account the well-being both of the child and the parents. Noze, what do you think about placement? Is there enough prevention in the legislative framework? Well, the Code on Youth devotes a full book to prevention, so I fully agree with Mr. De Vos. Placement is a measure that is sometimes unavoidable because you need to put the child in a safe environment, but it is the last resort measure. It has to be taken by a youth justice. Sometimes there may be difficulties in the family, and displacement is the last resort measure, which doesn't mean that it should be taken after a long time and long reflection. Sometimes fast action is needed, so an immediate placement can be decided in view of the circumstances, because there's no point in letting some situation degenerate. This is a way to avoid the situation to worsen. So the more prevention is activated early in the process, the less chances there are that placement is needed down the line. So of course placement is a difficult measure, both for parents and for children. So in my team we strongly believe that there is a need for fast action and for very young children to try and provide support to parents to avoid disruption. And if a placement has to be taken, it should be as short as possible, and we want the child to be back in his or her family as soon as possible. And for older children from the age of 10, 11, when things are a bit difficult, then we need to have a cross-cutting approach. We have different services like actions in open environment, and we noticed that it's very difficult for a young boy or girl to go and knock at the door of those services. So those services depend on youth clubs, schools, and psychomedical centers. So we want those young people could introduce a request as if it is not a real demand. So it is a measure that could avoid a lot of placement decisions. So you say that placement should be the last resort decisions. We have heard that many parents did not even have a say about this placement decision. So this means that something could be done before the child. Sorry, I didn't understand your question. I will ask the question to Mrs. Carlier. Let me say it in other words. It often happens that in disadvantaged families, one parent is absent, and the priority of youth services is not to rebuild the ties. As a youth judge, we also expect some work to be performed on the tie by other stakeholders. So I think that both the Ministry of Justice and the other services should be involved. That would be my priority. So I think that directors, advisors should be sensitive. Some of them are watching us, are online. They should be sensitive to these issues because it is bad treatment, a psychological bad treatment, and has to be perceived as such by everyone. Everyone has to realize that when a child is deprived of one of his or her parents, this is a bad treatment. And therefore, all the other services should try and support the youth judge or family judge. Yes, it's true that the absence of a parent is suffering for a child. That's obvious. Now, if I look at all the cases, I think that all the counselors on youth matters are quite sensitive to this concern and to the difficulties experienced by children. But there are many different types of situations. So we want to ensure that the child can enjoy the right to live with both parents, which is not always obvious because one of the two parents doesn't want to maintain any contact. And this is a suffering again for the child, quite obviously. I wouldn't say that all situations where one parent is absent should be addressed by youth protection services. Because there is a need to rebuild the ties, and so again, many services can support parenting. For instance, mediation, which is hardly used or not used sufficiently. We need to be quite careful not to refer people to specialized support. Youth support, for instance, because youth support for me is a last resort solution. Maybe other solutions were used, but maybe not to the full. And therefore, we need to focus on prevention and the family before referring them to any administrative solutions which are quite heavy and cumbersome. We need to realize that a family that is referring to a youth service already did so with a broken heart. You don't go there for pleasure. So that is something you need to take into account in the picture.
Do you have other things to share about legislative measures to avoid breaking down of ties? Well, prevention is critical to avoid ties to be broken. But I think it falls more within the competencies of my colleague and, of course, the Ministry for Justice is looking at this as well. These competencies are generally shared. As to the competence of the youth support service of the ministry, when it comes to rebuilding the ties and between children and parents, there are several things that we need to distinguish We have on the one side civil matters, the question of living arrangements between both parents does not necessarily require the support of the SAJ, the Youth Support Service of the Ministry of Justice. So, but in some cases, they can go to the judge. The family court has a permanent service, but it is first to the court that people have to claim their rights. I'm thinking of a situation when the children are not necessarily placed, but when it is the youth judge that has intervened, that has decided that the child should be placed, then the dialogue has to be set up between the different stakeholders. And about the question of Olivier and about who does what is the Ministry for Justice supposed to do, following the encounter with Marie-France and Olivier, there are information sessions that could be compulsory for the people who want to submit a claim or want to submit a request to a judge, to the court. Because once people are informed, after 2 hours of an information session, people will look at things differently. They will, for example, understand what are the consequences of a legal procedure. They will be made aware of the fact that it's a very long process. And it also means that they lose the control of their situation, because somebody else will make a decision about their lives, about their situation, instead of the defendant. Whereas if we can agree, if we can restart a dialogue, if we can all sit around the table, very often we can come up with a solution which is much more relevant than the solution that the judge may have developed after hearing both parties. Because the solution then really fits the situation of the mother, of the father, and of the children. Yes, Mr. De Vos. I'd just like to add something. Well, it's not really to the point, but I don't like to hear about mothers and fathers, only because actually in the last 20 or 30 years the kind of families has developed. When talking about supporting parents, it's a bit peculiar. We're talking about follow-up, guidance, and the very concept of parenthood is diversified. I would rather talk about supporting families and not so much about supporting parents. There are pluriparental families, monoparental families, recomposed families, or and it can be the child of the new partner who will do what needs to be done for the other child, or will do very nice things for him. So of course, classical traditional families, 2 children, 1 dog. But okay, that's one kind of family, the traditional family, but there are many other models of families. Well, when we tell children how they have been born out of the love between the mother and the father, but now today it is possible to use a surrogate mother to have a child. So things have changed, things have developed. These are new realities. And I think that we are wrong when considering supporting parenthood only. I would rather speak about supporting families. So being with the family, helping the family, supporting families, and not so much supporting parenthood. So, and a family, not just the biological mother, the biological father, and the 2 children. So, those who make up the family are not just the parents, especially in the case of separation and divorce. Well, indeed, we haven't made many decisions about this so far. It's very interesting when it comes to youth outreach, or when support is being questioned. Actually, the thing is that all the stakeholders, all those who are interested in the well-being of children, are there. And for example, we could have the case of a child who has built a strong tie with the mother of one of his friends, and so that person could also value the best interest of the child. So it's a progress, it's a small progress, but it's a key progress. Well, of course, once again, it's Mr. De Vos who triggers all the reactions. But you are right in dealing with that key question. And one of the things that the minister would like to look at is the modernization of filiation. So the idea is not to make a revolution. It's more about updating, modernizing the question of filiation. We have received a report of professors in family law, so we're going to study that, and we hope to be able to come up with a reform before the end of this legislative period. I'm thinking of very little children. Well, I think that with very little children, the process is too long. In Austria, midwives visit pregnant the women, the mothers when they are pregnant. That way they get to know all the family. They can feel whether that family needs support before the child is born, or they can prepare the family to the fact that the child may not stay with the family when he or she is born. And usually it takes 2 or 3 years before we find a foster family. And in the meantime, the child is taken out of the family, goes to a foster family, then a second foster family. And it is usually the third foster family where the child will live. And these children are deeply traumatized because of these changes, and it's a trauma that they will experience for their whole life. So it's very difficult to help the child with the therapy later on, because it's very tricky, and this is the first thing I wanted to say. And then about placement. Well, of course, not all the administrations are the same, but in my opinion, so a child is ill-treated in the fact that there has been a loss of the ties, not only with the mother and the father. Can be the loss of ties, with the enlarged family, and nobody knows how that a child will develop after that. What will happen with him or her after? And I've heard that we hesitate in placing a child when the mother, for example, is alienating or ill-treating, and the child may not necessarily be directly sent to his father. It is as if we wanted to place the child on another planet. Well, I think that the child should be sent to his father, to the other parent. And fortunately, today in Germany, it is the family that will be the first to be considered for the placement of the child before sending the child to a foster family. And I think that this is key because when the roots are torn, it's a disaster, it's dramatic. So we should try to avoid as much as possible a drastic breaking down of any kind of family ties. Mr. Noiset? When I was talking about ill treatment, actually we're doing our best. We're doing everything we can up to the collaborative expertise, but at some point we lack tools to go further. I'm not in favor of placing children, but placing the child in another parent, that is also, or in another relative. It's very complicated, but because sometimes the child doesn't know the other relative or the other parent where she or will be placed. So it's not just about family law. It does not fall within family law only, because in a case of ill treatment, it is not always the case, but if there is an ill treatment, a case of ill treatment, then we really have to collaborate and work hand in hand. I'm trying to clarify things here. Okay, well, let's take the example of a very young child who experiences a separation or a situation of ill treatment in his family, or in a reconstituted family, or with his mother or father. In any case, the environment where the child lives is key, and the code on youth support is clear about this. That child cannot remain in the environment because that is where he or she is ill-treated. We will first look at the relatives, the other parent. But we have to be clear in what we do. We have to be careful. The focus is on the child. The child is at the center. If the other parent will allow that child to develop himself, of course, that other parent will be the priority. The same goes with the reconstituted family. If it is possible to have the aunt, the sister, for the aunt of the sister to welcome, to receive the child, this is the first thing that will be done. So placement, as we say, a placement institution is really the last port of call. Let's not forget that during that time, the child is away from his family environment, and it's okay if it's a family, a foster family that is considered as a family. But in any case, there is something done with the parent, even if the parent has been ill-treating, even if it has been confirmed by a hospital team that it has been psychological or physical ill-treatment. But the youth judge or the youth counselor won't necessarily send that child immediately back to that person. But there is a difference between losing the ties and not living with someone anymore. One may not be capable to take care positively 100% of a child. This is not why that ties cannot be kept. This is not why there is not something positive that can be done. And in any way, while growing up, the child will have the need to see that person again. The child will ask questions. And actually, it's a guarantee to make sure that once they are teenage, they don't just blow up. But we should not ask too much to the parents. The idea is not to have parents face the same difficulties again. So here we're talking about conflictual separations, divorces, we're talking about youth court, ministerial service of youth, etc. But there are situations by which one parent is not doing well and the other parent will take care of the child without any legal decision, because actually both parents are responsible for their child, and that's how it goes. And then okay, we know that when we call in the PASG, that means that we, in that case, there have been already quite a lot of damages done, and that makes things more complicated again.
Another question for Mr. De Vos. We see that when ties are broken, sometimes children don't want to see the other parent anymore, and the youth services won't act. They can't do anything. There are many decisions where the child will be placed. My understanding is that nothing is done against the will of the child. How is it in reality? Well, I'm there to defend the rights of the child, so I won't tell you the contrary. I think that the child's life is key. Nothing should be decided against the views of the child is not something I would support fully. I think that sometimes decisions have to be made for the child despite his or her views or expectations. A magistrate will always rule after hearing and getting to know all the elements, all the evidence that is necessary to make the most relevant decision. So the question is not just to ask the child whether he wants to live with his mum or his dad, but at least the child should be given the possibility to express his or her wishes, that the child is properly informed, and that the child's development is taken on board. There is no ceiling in the age of children. You know, when looking at the issue of euthanasia for children, I realized that the age is a theoretical notion. When a child, 12-year-old child, is in palliative care, his reflection capacity is by far exceeds that of some teenagers, ages 16, 17, or 18. So I think that what matters is that children are taken care of by well-trained people, good professionals, and that the child's opinions are taken on board. Yes, a very last question. If we look at the legislation pertaining to young people, is there a real cooperation between the judiciary and the youth offices, or the youth services? Well, we just met a couple of minutes ago in the corridor, so I've been in my new position for only 12 months now. Of course, each has its own competencies when it comes either to the ministry or to youth services. But there are some areas where we can overlap, and we should meet. For instance, the National Committee on the Rights of the Child is one of those venues where we can meet and discuss together on various issues. We had a conversation with Minister Bettini not so long ago about the role that justice houses could have to provide support to parents experiencing problems. So there is a project there that could be put in place. So we are just at the very beginning of the process. But you know that with COVID-19, with the relaxation of some of the COVID-19 measures, now we can have face-to-face meetings, physical meetings. I would like now to come back to something that was said earlier about the child and where the child should be. In my view, the child should be at the center of all the processes. And whatever has to do with the child is a matter of concern for the child, should make sure that the child is at the center of the process. So we should also ensure that brothers and sisters, so siblings, should never be separated. There is a federal law, the Civil Code bans the separation of siblings. And during the making of the law at the Parliament, it was suggested that a child might also go to justice and take legal action. And realized that this issue was not mature enough to be addressed in very simplistic terms. So child should be given some support, of course, but when a child says no or when a child makes a suggestion, it is very important to see why he or she makes that suggestion, why he or she says no, what's happening in the family, what's happening in the life of that child. And this means that you need some experienced people to have a look at this and to look at the situation. But for sure, this reflection will continue, and several meetings have taken place, the outcome of which is that the child should be really at the center of our discussions and conversations, and that we should always act in the best interest of the child. Thank you very much for that. So what I'm hearing is that things are on the move. There are many projects in the pipeline. Oh, there is a question. Well, I have a question. When clients come to see me, some were alienated, and they ask me, isn't there anything in the law? Isn't there anything in the law that would say, like pedophilia, violence, between the members of the couple, there is no sanction, there are no fines. I heard some clients, some attorneys who said, well, there is defamation, but they would not advise this because this kind of file is not taken seriously. So is there anything that I missed in the picture, Mr. De Vos? Well, thank you for that question. It's a very touchy one. Here we are talking about sexual violence, sexual abuse on children. So indeed, from the moment such allegations do exist and sanctions are taken for something that is alleged but not proven or evidence-based, it might be seen as a way to silence one of the parents. And the mic is off. The battery is probably low. Or maybe it's time, I don't know. Okay, so this means that you could name and shame and vilify anybody without risking any sanction. well, you can always take legal action, because if you make some allegations, if you want to take somebody to the court, if you want to take legal action, in other words, you need some evidence. You can't just simply say, oh, well, the child should no longer see the father because the father abused the child, without any evidence of that. You need to make your case, otherwise it's useless. Well, if there is suspicion of sexual abuse, we are lucky in Belgium, because this is not the case in all countries. During the family court hearing, you have the King's prosecutor. The child is has been heard. The hearing is videotaped, and so we are there, the judge and the prosecutor, to decide together. So those allegations that aim at making sure that the child will no longer be allowed to see one of the parents is taken very seriously. So when we don't have enough evidence, we will then take precautionary measures, but we will not ban contacts. It's a case-by-case approach, of course, but we need to have enough evidence. In the absence of evidence, we will not be really concerned about the situation. Maybe there was a time where many of such fake allegations were made. Personally, I haven't been faced with those fake allegations so often, allegations of abuse and violence, I mean. Again, we have solid evidence-based files for all the complaints that are lodged by either parent in cases of domestic violence or in case of violence or abuse on the children. So we are well informed. Okay, you can always take legal action for defamation. This is something that can be done by either parent. So again, each parent can take legal action against the other for defamation. Okay, to summarize, we can say that we already have a good set of laws, that those laws might not be sufficiently implemented and enforced. We heard that a lot of changes have happened in terms of family patterns, and we see that there is some momentum, some initiatives in the pipelines, or that initiatives that are already up and running. So thank you to all the panelists, Mrs. Coudio, Mrs. Carlier, Mr. De Vos, and Mr. Naze, and Mr. Lezamito. Thank you very much. So here we are at the end of this conference, at last. I've tried to prepare a summary, so I'll do my best, but bear with me.
If that's okay for everybody. Okay, so this conference was titled Protecting Family Ties After Separation. We wanted to put prevention in the first place, because we all know that it's difficult to see families after separation, how they struggle. I think also professionals are struggling with that. Mr. De Vos just said also that, you know, families have changed. We are in a new world. The way families are together is totally different. The primary family, just mother, father, child, is not anymore. We have constructions, even constellations of families today. So I think the whole idea was to gather experience, to gather people at this conference who can help to start reimagine a family separation. Okay, so we wanted to trigger professionals, we wanted to trigger as well governments, politicians to start thinking. And we also wanted to do that with tools. Okay, so the first of all, where we wanted to start was we're going to look at the conference, all the topics. So the first thing that we wanted to see was what is the scope, where we have to look at, how far can we go. And I remember that Ursula Kuju said that we even have to go looking on education, you know, the first place where a child is, where we learn children how couples are, how people are, how separation can be done. We also have Nick Child, who said, listen, this problem doesn't exist anymore, but we are 50 years further, all right? So we have to put our in place of 50 years and then look back to today, what we have to do today. That was one of the things that we wanted to do with the conference. And also Jorge Guerra Gonzalez said, for instance, one of the things that we can do is shared parenting. It's not the solution, but it's a situation where you can prevent that actually it's also happening. Okay, so then we're going to see the perception, okay? What are the ways we have to look? What are the things we actually seeing or need to see? And one of the things is that a lot of things are counterintuitive. We think we see the things, but it's not like that. So that's really important. It's a really important thing that also experts in separation, experts in parental alienation, they say a lot of things are counterintuitive, okay? So what we learned from Jean van Hemelrijk is that also what we see is that couples, it's a mal-separation, meaning that they don't separate. They stay a couple, but in the wrong way. And a few weeks ago, a friend of mine said that, Olivier, I think today couples, they don't know how to be couple. And I recognized the thing that Jean van Hemelrijk said at that point. And then we have also Bruno Humbeek, who said that things we have to look is also to the attachment. It's really important and what it can harm a child. And then if a child is harmed in the attachment, how will this child behave as an adult in his own relation? So it's important to see to that, okay? And what we also see is the movie. I think the movie that we saw, I think your mind, of du bist, wie heißt die Film? Weil du mir gehörst. It's impressive how they put in a movie really the things, because I think a lot of people, parents and professionals will recognize what it is, what happened to Mia and her father and also her mother. Okay, so at that point we come to the obstacles. So if we want to do on prevention, what are the things that need to be done, or what are the problems that we're facing to do prevention, okay? So I remember that Hans Christian said that, you know, almost 30 years ago, that working together, it's important that professionals work together, because actually what happens, it's parents, they don't work together. So if the professionals don't work together, yeah, then it's not going to help or prevent the problem. It's going to help to make the problem worse, all right? So he already recognized that and said also that you know, like something like a lawyer for the child, somebody who takes really care of this child, who understands that the child is important. Okay, and then Marc Juston, the judge from France, he said that we have to listen. The child needs to be heard, but also listen. It's not just the voice of the child. And that's the point where I also come to the counterintuitive point. It's not what children say, it's really important why they say it, okay? And then also, and James said that the obstacles that we have also is that some procedures, the system itself, it's hard, it takes long, it takes too much time. So that's also an obstacle that we needed to face. But actually, there are some expertise, and one of the things that our minister said there was not enough expertise. I mean, I think there is enough expertise, there is enough knowledge, but it's not spread enough, and that's one of the reasons of this conference, to spread the knowledge, or at least to let know that there is the knowledge and that we can use that knowledge to implement in different professions. Okay, so what I heard is also that, and actually it's an example of Hans Christian Pristine, that Alexander and Sylvia, the judge and the expert, actually it's a tandem and it works. So these practices are really working to solve problems and also even to prevent problems, okay? And then also Marie-France Carlier, she has almost 10 years experience in how the court itself can work differently and also help prevent the problem. Okay, and then I'll be Marik, who said that mediation is really important even before you go to trial, and it's important to educate parents, because again, couples don't know how to be couple, and if they don't know how to be couple, they certainly don't know how to separate, of course. Okay, and then Amy Baker, she taught us some interesting insights, how we can deal with certain behaviors, especially for this child. Okay, we saw the best practices also in Spain, and then of course Brian, who learned us some ways how he dealt with these kind of problems. Okay, and then we had, of course, just the debate, which is about the laws. And then when we speak about the law, we speak about our minister, who was yesterday opening the conference. And actually, we're very proud that in Belgium, we're going to start with a project, where the expertise, where the knowledge that we already do, because we have laws, like Marie-France Carlier said, we have already laws that are advanced instead of other countries. So we have that privilege. We also have that privilege that we are a small country and that we have regions where we can just do things, and do things that's actually what is needed. It's not the blah, 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 is actually doing the things and trying to do the things different, but at least try it. So that's what happened. So it happened that we are in a small country. There are changes or other ways we work in courts. There is expertise that really helps. And when there is collaboration, when we work together, then it works. And not only for Belgium, we hope that we can do that as well. Oops. We hope that we can do that as well for Europe and maybe for the world. So there are already countries and expertise that we gathered on this conference that could use. So anyway, we suggest that other countries take that up and take Belgium as an example to go further. So I want to thank some organizations. First of all, I want to thank PASG organization to get, or actually the project that Marie-France and I sent in to support that. They supported us for this organization. They supported us for everything. So I'm thankful for them. I'm actually also thankful for the Ministry of Justice. We call it Team Justice, because not only the minister, but also the collaborators of the minister. Mr. Zamito Viaggio was with us today as well. Okay, and then also EGO, it's an organization who trains magistrates in Belgium. They supported us as well. And then, of course, the organization that we set up, it's actually the organization that is doing this conference, okay? Yes, and of course, there are some other people that we will thank later on, okay? Just one more thing. There was a famous guy, I think he's not with us anymore, but he said one more thing. And I have a gift. It's a gift that I brought. Or actually, during the conference, I realized that there were some rules. I mean, actually, how can we make this complex? A lot of people say it is complex. Family separation is complex. For me, it is not complex. I'm a child also from divorced parents, so I don't think it's complex. And I'll tell you why. Actually, with the separation, there is nothing wrong with the children. There is everything wrong with the adults. So for me, that's really simple. So I have created, together with my team, 3 rules. I don't like to call it rules. I like to call it stars. And there are 3 stars that I learned today and yesterday. And I said, I have to tell that because maybe it can help people because it's really simple, okay? So these 3 stars, you can consider it like, you know, restaurants. You get a 3-star restaurant, which is the highest level, and one restaurant, I think you can get 4 stars, but it's just one in a year or whatever. But 3 stars, you want to be 3-star parent, you want to be 3-star practitioner, you want to be 3-star judge, okay? Then you use these rules or stars. And the first star is very simple, okay? Recognition. Everybody needs to be recognized. Mama is mama, papa is daddy. Mama is mama, papa is papa. But daddy is daddy. The child is a child, but also the judge is the judge. If the judge is on the move, he needs to make the decision above the heads of the parents and not leave the responsibility to the parents or the children, and the practitioner don't need to take over, okay? He needs to be supporting the parents. We heard about placement in the debate, how hard it is that you don't see your child because you have, you know, you have a law, you have the papers, you have custody, but due to the broken line, the broken tie, you don't see your child, and then your child is placed. How does the child feel? How does his parent feel? No, I think it's important to recognize any one of us, not only the parents, but any one of us. That's important, okay? And then the second star, it's easy to see. You are partners or you are ex-partners, and then you are parent, okay? But it's not the same. You can be ex-partners and still be parent. So I think it's important what we learn also is that the emotions of the partnership or the separation, whatever, is overruling the responsibility of being a parent. And that's a problem. We cannot allow that. Okay, so this is the second one. And sometimes I ask people, or people ask me, yeah, it's easy to say how you do it, okay? Well, I'm thinking that both parents, you need to love each other, even after separation, because you need to be the example for your child. There is no other way. You have to transfer that energy, you have to transfer that love to your child. And I know it's not easy, but you have to. And then on the other way, ex-partnership, you hate your ex. No, be grateful. I mean, you're separated for a reason. It didn't work out, all right? If it didn't work out, I say, okay, so you learned. If you learned, you could grow. Be grateful and thankful for growing. So for the partnership, you can be grateful, and for the parents, you need to love each other again. So that's the second rule, all right? And then the third rule, or the third star, I think it's one of the most important. And it's one of the things that I really care. And that's why I'm doing with my profession, because I really care about the children, all right? The children, like I said, family separation, there is nothing wrong with the children, everything with the adults. Well, they're not responsible, nor they can be the messenger. All right? So these are the 3 stars. I learned also, I recognized it in every knowledge that or practice that I heard these 2 days. So that's what I wanted to share with you. And maybe it's an easy rules, and you can implement it, call it different, call it flowers, or call it rules, or whatever. But maybe these 3 rules, really, if you implement them, it helps to prevent the broken ties, all right? So that was my little gift for the day, and I hope you can spread that to your people around, to your network, also your professional network. So then we come to the real thank yous, all right? So I'm very thankful to Marie-France that we could do this together, because we met in Philadelphia exactly almost 2 years ago, I think. It's today or tomorrow, Marie-France? Tomorrow is exactly 2 years. So we send in the project, so can you come up, please? Okay, so we didn't do that alone, all right? So we also had other people around, and we had the executive team. The executive team are these people, all right? And 3 of them are in the hall. No, 2 of them are still in the hall. So that's Jorge, please, can you come? And then Ursula, please, can you come? Also, Sylvia was here today, but she had to leave. She had to take the train back to Germany. You remember her as well. And also Bill Burnett is the president of the PASG, and I'm very thankful that he always supported us to do this, the 4th conference, which has been a roller coaster due to at least COVID and whatever, these kind of things. So I'm very thankful to these people. Okay. Then, yes, I think I have a list, and I hope I don't forget people, but I have to see. So first of all, I want to also thank Emma Bale. She wrote this beautiful song, what she actually lived. She has been a child not seeing her father for a long time. She and her sister, they went through it, and Emma, she wrote a song especially for this conference, and I hope we can spread it as well, because she's proud of what she did, okay? But like she said in her song as well, and it's one of the rules already, she's not responsible. That's what she said in the song, okay? So I also want to thank all presenters here and online who supported this, and I know there are a lot of more people who applied to be presenter, and I think that we will put that content as well, because it's not finished, the conference today. I think we go further for that. I also want to thank the minister and his team who also supported, who was very, I think, even brave to show how much knowledge already there is at that point, and the actions that he will take, and the confidence that he has in the expertise in his own country and outside the country. I also wanted to thank all PASG members to follow us, to support us, especially the technical staff, because we decided to do this conference hybrid, and hybrid is live and online. I mean, if you go online, then it's easy. If you go live, then it's easy. But both, it's not that easy. I learned that technique also for the sound and whatever. So I wanted to thank Tom Jansen especially. He's also a member from the PSG. He did the conference before. He's in the back. All right. And also Tom Rummes and Dries van Kraan, the two other guys to the left and to the right. I can tell you these guys are really experts. You know, you need them when something goes wrong, and definitely a lot of things went wrong, and definitely they made the difference. So thank you for that. Okay, and then, of course, I wanted to thank also Filiatio. It's an organization in Belgium. It's Jerry Legrel who helped us also. He supported also financially to get this done. Okay, and then at least I wanted to thank also all the audience and the public who were live here and online, and then all the parents and all the children who will benefit from this, because actually we're asking you, please spread the word, and try to do that for the best interest of the children. Okay?
And thank you to Olivier. Thank you, Olivier. It was very a great pleasure for me to work with you. We had never any disagreement. And we didn't know each other, and we didn't know in which ship we had to navigate together. And thank you so much. It was very powerful.
Well, without PowerPoint, I really cannot talk in public. But it seems as if it was teamwork. It was not. So 90% of the work did these two wonderful persons, Olivier and Marie-France. And, well, look at that. It is not obvious that we are here, that the minister came, that we get financing and the translation, that we are all here. You can imagine in 2 years, it was not so easy. And 90% of this work, they had to do that, and it was not easy, and I want to thank them heartily for doing that.
Thank you. Because sometimes it was hard, and you were there to help us to take the good decision. It was not always easy to take some decision and to go on. Thank you so much. Yes, it was
translators as well. They have been very hard for us.
I was a translator once, and we had a lot of speakers who talked. We had a lot of speakers who talked so quickly that I really felt sorry for the translators. And that's why I really want to thank you especially. You did a great job. Well, I hope I didn't hear it, but I think so.
Okay, so actually I wanted to finish that with follow us on the website, on the Facebook. We'll now have time to work really on the content on that. And as Bill Burnett also said, next year there is a new conference in Australia, and we hope to see you all there together. Okay, thank you very much.
Thank you.
Bye-bye.